Any mention?
Yes, how do you?
Item number 1.
No, lawyers also appear. Right.
May I please, Your Lordship?
Yes.
Lordship,
You're not properly dressed. Please switch off your video. It's a matter of 2 weeks.
I'm really sorry, Lordship. I'm really sorry.
It's a matter of 2 weeks, yes. For the orders.
Any mention?
I beg to mention item number 36, my lord, on behalf of the respondent state. My lord,
36.
36, my lord. Senior,
Bararilang Boman.
my lord,
Who's
senior,
for the petitioner?
For the petition, Lordship. This is regarding the death of the next week, Lordship.
Death of?
Death of the doctor, Lordship, who fell down from the gorge.
Okay. After? 1 week.
1 week, Lordship.
Okay.
Lordship, I have a similar prayer for item 33 for the petitioner.
33.
No objection.
1 second.
1 week, Lordship.
1 second. 1 second.
Please.
Yes.
Pray for 1 week,
Right.
Lordship. I'm fine.
Lordship, I beg to mention item number 34.
Yes, Mr. Dingo out of hospital is still there.
He's out of hospital, but is still in.
Yes. He listed after 3 weeks better. He'll recover because I believe he was hospitalized. Yes.
Lordship, I beg to mention item number 33 or 32 on behalf of A.H. Carvalho.
On behalf of
A.H. Carvalho.
32.
Lordship,
Electrocution matter, madam.
Electrocution matter. When?
3 weeks, Lordship.
3 weeks. Why he's gone abroad? Okay, 3 weeks.
Lordship, right.
Item number 1.
Please, Your Lordship. As my friend just informed me, he's entering appearance on behalf of Muda for respond number.
Muda.
Matter, my lord. I'm entering appearance for Muda. My lord. So I've served him a copy, my lord. So he believes that he wants to take some instructions on the matter. Very innocuous prayer, my lord. So I've had 2 complaints that I've filed before Muda questioning the unauthorized construction conducted by my neighbor. Since December, these representations are pending before Muda. They've not acted on it. They've not even acknowledged it.
You are?
I'm a resident of GS Road, and my neighbor has commenced construction in a
In a
plot.
commercial complex.
My lords, they've initiated.
Residential complex.
Mine is a residential cum commercial. There's the purely commercial establishment.
I'll take instruction. I've just
No, you
received
have
it.
issued notice to the private parties also.
Yes, private party is there, my lord. Respond number 6.
Then private respondent minutes. And for the state, respondents 1 to 3.
First, has sent an account to the petitioner. Issue notice.
Number
MS
6.
Esham, except on behalf of respondents number 1, 2, 3. Mr. SD is present, except on behalf of 4 and 5. Notice to issue to respondent number 6 within 3 days. Well, just after 2 weeks.
Well, if your lordship can kindly have it a little earlier because of the nature of the construction. We flag very serious concerns with this construction.
When can it come instructions?
2 weeks, man.
Let it come 2 weeks.
Lordship. Obliged.
Obliged, minutes. Obliged.
Item number 2.
May please, Your Lordship. Lordship, this is a Nukma matter, my lord.
Yeah.
Here we are aggrieved by the impugn order passed by the executive member, deputy CM and chief executive member, my lord.
What is your grievance?
My grievance, my lord, is that the main
Finally, he decided who Nokma is on this case.
lordship.
Who are you? You are?
I am the direct descendant from the undisputed Nukma, my lord, Tungre Sangma. So my claim, my lord, before the court was that I am the direct descendant, whereas the respondent, my lord, is from another community, my lord, Coach community. That was never examined, my lord.
From coach community?
Yes, my lord.
Now, your grounds for challenge limited to procedural or is it?
It's procedural, my lord, because the main issues were not framed, my lord.
In these proceedings?
Yes, my lord.
Yes, you take notice then.
Lordship.
Mr. AG Moment and Constitutional notice. Mr. SD. Still accept notice on behalf of respondents 1, 2, and 3. Notice court response 4 and 5 within 3 days. just after 3 weeks for instructions affidavit.
Hello, my lord.
Item number 3.
Yes, Mr. Sam.
Please, Lordship. This is also is a Lokma matter, Your Lordship, whereby the petitioner here is challenging the impugn order passed by the CEM of
Well, the order, let's see.
GHTC. This Lordship, this is the last page, Your Lordship. The operative part of the order, page 54, my Lord. Page 54, Annexure 9, my Lord.
Very short order.
Yes, the page 55 is the operative part of the order. May I read your para 12, my
The
Lord.
whole order.
Lordship.
Appeals referred,
Yes.
details of so and so.
The pursue the appeal memo challenging the order dated so and so.
You didn't sign the appeal memo also.
Lordship.
Read second paragraph.
Second paragraph. Yes. We were the appellant. I have no pursued the responsibility.
All of the appearance didn't sign.
Appeal was prepared in the name of appeal memo. Zero signed the memo. Yes, of course, maybe.
Who is this, sir? Dingon Maraksi also
Yes,
for the court?
yes. Before this
Is
court.
one of the petitioners?
Yes, one of the petitioner.
My lord, this petition which has been supplied to me is the order, my lord. That is on page 54. Is not a complete order, my lord. Only 2-page order is there.
2 page only is there.
Yes, my lord. My lord, may kindly see serial 1, 2, and then
Yes,
the
what is this? From number
12,
2,
13,
jump to
14.
number 12. What is this, Mr. The main impugn order also, you missed out how many pages?
So probably there should be another 2 pages.
Lordship, I will withdraw it, Lordship, because I go through this, I got only this one order. Will
This is
withdraw it, Lordship.
height of negligence. You have no respect for the court, you have no respect for your other counsels. That means you give any kind of petition. I didn't notice that. He said very short order, 2 page, and from paragraph number 2, nothing. Now next page, paragraph number 12.
Yes, did you overlook, Lordship? I will withdraw
Overlook,
it.
is an impugn order. This is very unfortunate.
Otherwise, my lord, the page that para 12, of course.
You want to say a truncated order was in the middle, you don't know what the reasoning to arrive at that finding.
We'll withdraw it, Lordship.
Mr. P.T. Sangma, please not withdraw this petition, will be to file afresh.
Lordship.
Praise allowed.
First floor, Lordship.
Item number 4.
Mid,
May it please, Your Lordship.
yeah.
Lordship, this is a matter whereby, Lordship, I'm a teacher, Lordship, recognized under the government, primary school, Your Lordship. Lordship, I have submitted a document which,
Sit down, sit down.
for, so the main crux of the matter, Your Lordship, here is that I'm supposed to be retired. This year, however, Your Lordship, I was forced to retire last year. My superannuation period in accordance is joining.
You supposed to retire last year.
No, Your Lordship, this year. But there has been tampering with the entry made in the service record, my service record, Your Lordship. My date of birth, in accordance with the entry, Lordship, which...
No, now as per your date of birth record and service book, when are you due to retire? This year?
No, this year, Your Lordship, in August. Your Lordship, that is evident from this...
You're seeing correction of date of birth.
I have sought for, Your Lordship.
When is, where is that?
Your Lordship, I have sought for, which is an annexure 27.
Next year 27?
Yes, Your Lordship, which is the first
Page
letter...
27 you mean?
Annexure number 9.
Request for correction 17 October 24.
And prior to this, Your Lordship, I have even approached, but there has been denial of my acceptance of my birth certificate. So, Your Lordship, upon...
6 August 19. My child date of birth 26 August 1967.
Yes, Your Lordship.
Okay.
And Your Lordship, that, as per Annexure 8, which is at page 26, Your Lordship.
So you want to retire next year?
Not this year, Your Lordship.
This year to retire?
Yes.
Are you still working now or you retired?
Still working, Your Lordship. I'm in service.
Then if your date of birth is 1966, then you should have retired. You're retiring in August.
Yes, Your Lordship. As per the actual document which I've relied, Your Lordship, at first instance when I joined the service, I've relied on the school certificate, which is at Annexure number 3, Your Lordship, 17 is a type copy.
Oh no, sorry. You see? Sir, see something? $67. Okay.
And
67.
And annexure number 4, Your Lordship, is my birth certificate which I have obtained, citing the date of birth as 26/8/1967.
Where is that?
Annexure number page 18, Your Lordship.
Page 18.
Obtained in 2019.
Yes, Your Lordship.
Subsequently, my lord.
Subsequently. But Your Lordship, upon filing of necessary representation,
You received 19. So did you furnish this to the authority?
we've already furnished, Your Lordship, but it has been denied.
What do you mean be denied?
Denied, Your Lordship, may kindly come to annexure number 12, which is at page 31. Was denied on certain observation made by the special officer to the Government of Meghalaya Education Department. He has relied on the subsidiary rule number 8, Your Lordship, of the...
You retired or still working now?
I'm still working, Your
How do you
Lordship.
work when they say you're supposed to retire in 31?
Your Lordship, in accordance, I was not even listed in the list which is prepared for the pension last year.
Getting salary now also?
No, Your Lordship.
My lord,
It
she
has
has
been denied
retired.
since last year.
She has retired, my lord.
Then?
No, Your Lordship. Examination needs to be made, Your Lordship, in this matter, since the special education
So why do you come
officer.
now? Why do you come at this stage after you retired?
I'm not retiring, Your Lordship. I'm still in service.
No, that time when you gave your representation, you should have come to court at that point of time. You're
My
giving
lord.
now, that time has gone.
Your Lordship, instruction was there from the state respondent that I should file necessary letters, on which I have filed, Your Lordship, which is
don't
page
think you're-
annexure 28.
You'll get any relief.
But, Your Lordship, there has been a misconstruing of the service rule, Your Lordship, of the FR and SR of the state. It has relied on service rule, subsidiary rule number
They're
8.
letting you teach.
Yes, Your Lordship,
How
at
is
present.
that possible?
My lord, even the application is October 2024.
Yes.
My lord, she retired in August, my lord. And so far as her pension, my lord, the status of the pension is the
Yes,
IPS
17
is yet.
October.
My lord,
That
the
is the
representation was submitted after the retirement, my lord.
But, Your Lordship, there has been clear admission from the part of the
Where is it?
respondent, Your Lordship. My retirement should be, the superannuation period is on 31st August 2025.
Where is that?
Annexure number 8, Your Lordship, page 26.
What is this?
Is a income certificate, Lordship, issued by the respondent number 5.
Even this one also has a
SDSEO.
superimposition of the date on top. Look at the date. July is superimposed on top. 23 become 24. Yes, MS Conley.
My lord, she has retired, my lord. Even
Take
the
instructions.
and
give benefit
the
of
status
notice.
of her pension is yet for approval, my lord. As per my preliminary instruction, the IPS is at the stage of approval, my lord. Once it's approved, my lord, the pension will be initiated.
Just get instructions.
Your Lordship, I've relied on the Meghalaya service pension rule as well, Lordship.
See,
The prior
Mr.
retirement
you
list should be
retired
prepared.
last year. You've come to court 25. I heard Mr. S.R. Lingdo issue notice. MSR Conley present acceptance on behalf of respondents number. All the respondents.
1 to 5. And Your Lordship, I've made the headmaster of the school, which is working presently as a
1 to 5,
necessary party.
1 to 5, no notice to the school at 2, 6 and 7 at present. List after 2 weeks for instructions. Let's see what instructions they bring.
Your Lordship, let notice be issued to the headmaster.
No, not now. Like this.
Item number 5.
What is this?
Madam, this is with regard to non-tribal gate, madam. But the impugn order, Your Lordship, kindly comes to page 54, my lord, annexure 6.
Under what some circumstances they've issued this 160 BNSS?
BNSS.
What's 160 BNSS?
It's
Is a
equivalent
public
to
property-
144, Your Lordship.
Is equal
of
to
the old
140.
CRPC.
Now, my lord, this issue is covered by an earlier judgments of this honorable court, my lord. And I have annexed at page.
Then I can't take up this matter then.
Lordship, I
I argued this matter before the division bench.
I was there for the state, Your Lordship.
You're there for the state?
Yes, at that time.
Just before any other bench of me.
Apply, Your Lordship.
Item number 6.
My end is small one.
Yes, Your Lordship.
Wait, please, Your The writ has been filed for threatened action, alleged threatened action, my lord.
I think we'll do one thing, Mr. Advocate General, because that this is connected to the other.
One submission I have.
There you are defending the creation of one central bonded warehouse. Here you are proposing the creation of another one. So
No,
that if it goes to the division bench,
one submission, my lord.
cancel out each other.
No, one submission.
My lord, what I'm praying, my lord, the pleadings are complete, my lord.
One
In this
submission,
matter,
my
we filed rejoinder also. And moreover,
The issue is, my lord, that the issue they are saying that you have created central bonded warehouse. And central bonded warehouse, and under the law, under the rules, we have power to create more than one central bonded warehouse. So what they are saying is that you are proposing to create central bonded warehouse, therefore I have a right to file a writ petition, my lord. That, your lordship, that right is not there. And your lordship has stayed my hand. I have no problem, matter is referred to division bench, but I have a right in law, because this interim order is coming in my way.
What interim order?
Interim order status quo to be maintained, my lord. That to that extent, my lord, I am saying that the order is vacated if the matter is referred to division bench. I have no issue. But so far as the interim order is concerned, my lord, I have a right under the law, under the act, and to create central bonded warehouse under the rules also. But because of interim order, I have not been able to take steps, my lord. That's my.
First, they have to defend one, my lord.
And if you lordship,
like we are on same page in defending one bond, central bonded.
We are not there. The stand of the state government is completely different, my lord. The stand of the state government is that the grievance of the petitioner in that case is that by creating one central bonded warehouse, state has created a monopoly and given certain powers to the central bonded warehouse. The government's stand is that government can create one or more bonded warehouse. There is no issue in that. Under the law, I have a right to do it. The matter was considered by division bench. Division bench passed the order that if the grievance is taken care of and addressed, if your lordship will see, because this matter can be disposed of, the order of the division bench filed by my friend only, my lord, one that monopoly issue can be looked into, and kindly see the page, my lord, page 166.
So will this cancel out the division bench matter also?
Your lordship, so therefore the problem is,
yes,
if your lordship will
answer a question.
Yes,
suppose you'll cancel the division bench proceedings of the
by granting,
because are they seeking to maintain that the setting up of one central bonded warehouse is not creating a monopoly, and then the other people you are challenging it, or you defending the
defending. They are defending. They are.
We are defending it together, my lord.
We are defending
defending the creation of one central bonded warehouse.
Yeah,
not to cover a new proposal.
No, one
multiple which other people want.
They don't want that also, my lord. My lord, the International Spirits Association has come before this honorable court. They are the manufacturers of liquor, my lord.
Kindly see the order, my lord, at page.
Challenging the rules by which a central bonded warehouse was created in Meghalaya, my lord. There we are private respondent and state is the state respondent.
Page 132, my lord. Page 131 and page 132.
132.
Yes, my lord, that third paragraph at page. It is made clear that as long as the state can demonstrate that the creation of centralized agency does not enable such agency to differentially treat manufacturer, whether by conferring benefits or otherwise, apprehension express would have been taken care of. Modification of the revised would should be presented by way of affidavit by state with the appeared next date, my lord. What has happened, my lord? And now kindly see the page 129. The earlier order of the division bench, my lord, page starts from page 127 and 20th June order, my lord.
Yes.
Now, yes, my lord. Page 129 at the top, paragraph 4. The essence of petitioner contention is that different sets of rules are applied to different suppliers of liquor to CBW. The CBW is a monopolistic position to control the quantum of supplies obtained even through CBW may ensure that it takes supplies from every manufacturer, yet quantum of supplies would be dependent on the extent of income or profit of CBW is able to glean from the. So the issue is, my lord, that whether creation of one leads to monopolistic or not. The government is of the opinion and it has taken into consideration that we want to create more than one.
But that means you admit to creating a monopolistic situation.
The question is not of because we are contesting this matter on two grounds: whether we can create the central bonded warehouse or not. That is my power under the
now in the rules envisages only one. Just
no, there is no. If it is there, I have no. Under the rules, we have right to create bonded warehouse and central bonded warehouse. Kindly see the rules, Mila. That amendment also. If my friend can show, because we have never, in fact, even in the license which we have issued, we said that we can issue and modify at any point of time. Kindly see one the notification regarding his right Mila, and the rules also. His right comes from page 38. What? And there is no such right, my lord. Page 38 is the license given to the petitioner, my lord. And if your lordship kindly see paragraph 2, it shall be required of the holder of this license as a condition of remaining in force that he shall duly and faithfully perform and as abide by following conditions and by provisions of Meghalaya Excise Act as adapted by Meghalaya, as amended from time to time, and by all notifications or rules which have or which may from time to time be published or made under this FAR relatable to license, and shall cause all persons employed by. I am saying that notifications which are in place or which may be issued.
It says it gives the power to create one central or others.
And that also, kindly see, I will show that there is that rule also. I will say, kindly see page 40 and the clause, page 40, clause 18.
My lord, may
the clause 18. Let me finish. Then let me finish. The licensee shall not be entitled to any compensation or cancellation of his license and abolition of central bonded warehouse as a result of any policy of government or any other regions. And now your lordship has put the question. You show me the bonded warehouse, my lord. Kindly page 76, the amendment.
Yes.
And this your lordship will see in insertion of new clause small Roman 2a in rule 2. In the principal rule, in rule 2, after existing clause small Roman 2, the following new clause shall be inserted, namely, small central bonded warehouse means a licensed central warehouse where IMFL, beer, etc. import as adopted by and so and so. So it is a licensed bonded warehouse, my lord, and there is no line anywhere, any law. Even if your lordship will see the Parent Act, Excise Act sections.
Because the central bonded warehouse means a license.
License is a licensed bonded warehouse. A licensed vendor.
This insertion has been done.
Yes, this means we are creating a licensed central bonded warehouse.
And earlier on, how did the rule read?
Because there was
one.
No, there is nowhere we have got 40.
Even in the unamended rules, it said one only.
Our unamended rules provision was for bonded warehouse. There was no provision of
central bond, only one central bonded warehouse.
No, there was no provision. There was no entity called central bonded warehouse.
How we created then
this by amending this new 2A by creating a new entity called. By creating a new entity called
and they came into existence.
I gave them license.
They came into existence.
Now
you say central bonded means a licensed central warehouse where so.
It's a license which I can give it to 20, even 30. Where is the restriction in the rules? And kindly see the Act itself, my lord. Section 16. Their right comes from Act itself, my lord. And my lord, no, my lord, I have no problem. My difficulty is, I understand, my lord. My difficulty is that
I can be loud also.
Your difficulty, my difficulty is that my difficulty, my lord, there is no basis for the
stay. Matter was heard on the day of motion, my lord.
And no stay was granted on that day, my lord. There no relief was granted. Kindly see section 16.
How can advocate say anything?
I can say whatever is there in the law. If your lordship will kindly see
his affidavit, my lord. My lord,
kindly 16. The excise commissioner with the sanction of the board the establishment of or licensing of breweries and warehouses. The excise commissioner with the sanction of the board establish a distillery discontinue license, my lord. imposed construction of district.
This is the
So
old
the,
Act 1910.
this is the act which is we have we are following it,
Yes,
my lord.
we're going to sit down.
And the
But what I'm
position
trying
is
to
that,
submit,
my lord, my case is that only on the basis of threatened action, my lord,
What is
no
asking
writ
me
like.
question?
Yes, yes, yes. Let us hear him. What do you have to say?
My lord, the matter was heard on 29/11/2024, my lord. The leading counsel in this case is Mr. D.K. Mishra. Advocate General was heard on that day, my lord, and Your Lordship was pleased to grant a status quo on that day, my lord. And after that notice was issued, we were supposed to file affidavit. They filed affidavit, we filed rejoinder, my lord. Now, what I pray that the matter may be fixed for either admission hearing or hearing, my lord.
Your lordship, if your lordship kindly see the order of your lordship 29/11 to 20.
All these objections were heard on that day also, my lord.
No,
Because see the insertion of that clause 2, like you say, brought about the central bonded warehouse, of which the petitioner were the beneficiaries of.
Yes,
Correct?
we have given
they,
the
they
license.
established that.
Yes,
right?
my lord.
Now your proposed action is creating more central bonded warehouses.
Yes, my lord.
Right.
Yes, my lord.
And so they agree with that.
No,
Now, just please listen. They agree with that, and they've come by a writ petition.
Correct.
So while at the initial stage, prima facie, I said fine, since you've given them the exclusive license, whether additional ones.
If they show me one line, one word, my lord.
Listen.
Yes, my lord.
So anyway, so now status quo order was passed,
Yes,
and the
my
matter was supposed to be heard expeditiously. But then looking at it now, it's linked totally to the other matter.
My lord, I have the issue is, my lord, whether they have.
In all fairness, suppose this court passes some order in a single bench.
No, that's why I'm saying your lordship vacate.
Right, that's as per the acts and rules which are prevalent.
I bow down, my lord.
You have the the competency to create more. So fine, that is held by this court.
Yes,
right?
my lord.
And
So,
then, but in the division bench now,
no,
you are seeking
my
to
lord,
maintain
I'm not
that,
on. I fully bow down. I
there.
fully bow down, my lord. I have
How? See, this court has to.
Yes, my
we
lord.
have
That's
too much
why, my
judicial
lord,
discipline also.
on first day also, when the writ was filed, I said, my lord, that the matter is pending before division bench. I fully bow down. And therefore, now what they do is, my lord, they get the interim order without any basis. My grievance is with regard to interim
There was
order.
application for vacating.
No, your lordship if your lordship kindly see your lordship's order 29/11, and that says that it is for admission hearing. At admission hearing, your lordship feels that this matter should go before division bench. Then I have, but the interim order cannot. The division, the matter, my right under my case is that there should not be any. My hand should not be tried on the threatened action because they have to make out three.
Order and we put it for division bench.
Your lordship,
My lord, because I'm not the arguing counsel in this matter, my lord.
Yes.
I'm praying for any day, my lord, maybe next week sometime.
So
The matter.
the thing is that this court finds some trouble, not on the merits of the, not on the but on the the facts of the case, not on the merits. The facts of the case that it's intertwined with with the division.
My lord, otherwise also they'll.
And the thing is that now, if this court passes some orders, then it'll go and appeal against. Then
my difficulty is where. How do I challenge this order? Where do I challenge this order, my
We'll
lord?
have it day after tomorrow.
Well, day after tomorrow will be some difficulty. My lord, Mr. is not available because today is also not available. Next week sometime, my lord.
My lord, because
otherwise
your
also
lordship, if I recall, if your lordship would.
This is a tentative view of the court.
This is your lordship kindly recall. If your lordship, they say.
Please listen.
Yes, my lord.
The court not hearing this matter.
Yes, my
we were putting it for division bench. We don't want any.
No, because I have one issue, my lord, one submission to make. Your lordship may place it before division bench. I am praying that the interim order be vacated.
We'll make it when the matter.
Interim order was only for one day, my lord.
26th of March.
Fine, we'll extend 26th March and we'll send it.
Your lordship kindly record my submission because my difficulty is that the interim order is not maintainable. Neither balance of convenience is there, nor prima facie case is there, and because I need not, because when I show to the court that there is no merit in the case, my lord, at least I am entitled to relief, this much relief only, my lord.
We'll vacate it. We'll make it operative till when's the matter of fixed
on 26th of March.
Operative till 25th.
Your lordship, because they are not entitled to. They are not entitled to stay for single day, my lord. They are not entitled to stay for single day because ultimately we are all bound by law. We are all bound by law, my lord. We are bound by law because law says that he has no right to show any case, my lord.
Law is otherwise.
Next week is what? Next week is we are now it's 24th. Okay, we'll have it on the 4th as a fixed matter. Mr. Archival General, but take a tentative view is that we will extend
Your Lordship,
maybe till that date.
my right under the stay is getting agreed.
Your rights can be.
No, my lord, your lordship, the stay on that day, I remember distinctly, my lord, that stay was for 1 day only.
Yes. Just on 4th of March is a fixed item. Yes.
Please, Lordship. Lordship, this matter, Lordship, all the respondents have filed their affidavits.
All are filed. But your file also?
Lordship, we're not.
Yeah, what do you want? 3 to 7, they file who? 3 to 7.
I'm for respondent 80, Lordship. We're not filing.
3 to 7 whom? Yes, MSS Daru submits and we have respondents 3 to 7. I will file the course of the day. This is a matter for 2 weeks for rejoinder if any.
3 weeks.
2 weeks, yeah.
Give your blessings.
Item number 8.
My lord, this matter, my lord, I have examined. Sorry. For this side. This matter, your lordship, kindly see. There are certain things which I must place before the court, my lord, because I have seen certain developments. And those developments are really troubling me, my lord.
Colleagues, last time your lordship told me to inquire. Your lordship recollect about during Assam time, I think your lordship has done this case before separation. Then I found out your lordship in 1992, your lordship was defending the state.
Defending the state?
1992, my lord, that please show me the order, 90. And my lord, they have gone back to the tribunal. They have gone back to the tribunal.
After checking the orders, I found.
Only after the liberty granted by your lordship. At that point of time, they did not remember the order.
No, the front order copy. Just after going through it, I just followed.
What's the order? Just see the
order.
Lordship,
I'm sorry, your lordship. I should have checked it.
This was in 1999.
92.
In almost all matters have appeared against the state, my lord, in Supreme Court.
I mean,
this is the order, your lordship.
It was heard in 16/10/98 and orders passed 6/8/99. Just anything.
But I have serious objection to this prayer, my lord. I have a serious objection, my lord, to this prayer, my lord.
For recusal?
I have serious, my lord. Why do I make this prayer, my lord? Is based on certain regions, my lord. Kindly see the petition, my lord.
Will it have any impact on this?
Nothing, my lord.
On the present.
No, since your lordship inquired, therefore I just.
There is nothing because inquiry is because in all matters your lordship has been there in the state, my lord. So, and they have no issue on that.
In fact, some of the applying the start principle order issued by Secretary Executive Committees and so relative. Why the Secretary Executive Committee issue orders here? In what context?
There is no context, my lord. There is no context, my lord.
Inquiring, therefore I just place it before your lord.
Kindly see, my lord. Kindly see the petition, my lord. Page 81, my lord. Very strange, very disturbing also to me, my lord. This whole petition, my lord. How this has been. Kindly see the petition, my lord.
Yes. Which page?
Page 65, my lord.
Which petition?
The first appeal. Page 65. This.
No, your lordship, before the appeal, delay hasn't been conducted yet.
No, I'm coming to the delay part also. I will come all aspects now. I will cover, my lord.
No, but Mr. Archival General, they have serious objection to this court here the matter, yes?
No, my lord. See, so far as my lord.
Page 18.
65, my lord. Kindly see, this is the page 65. This is the order passed by the because the petitioner, my lord, at that point of time, came to, he filed the writ petition number, kindly see the writ petition number 44 of 2003, my lord. This is the same, this single judge? Yes, single judge.
Yes.
This, the single judge, my lord, or learned single judge order, my lord, is page 65.
Yes.
And in this order, if your lordship will come, kindly, the objection was filed by the petitioner, stating that the land acquisition proceedings under the old act and invocation of emergency clause is bad and it should be set aside. This was the prayer that the land which was being acquired under the emergency clause is bad and set aside. This was the challenge, my lord. This challenge writ petition of the petitioner was dismissed, my lord, saying that the land is rightly acquired under the old act, my lord. To that extent, there is no issue. Now, kindly, this was taken to the division bench also, my lord, page 81. And division bench also by detailed judgment and order, my lord, page 86, dismissed the challenge of the writ petitioner.
Yes.
And if your lordship will see the last paragraph of the division bench order, 85, page 85, bottom, my lord. In view of the above mentioned fact, we find that learned single judge has committed no error in law in dismissing the writ petition. Learned counsel for the appellant lastly submit that leaving the residential house if remaining land of the Maxwell estate is acquired, the appellant has no objection. However, there is nothing on record to show how much portion of residential house, if any, is constructed apart from admittedly writ petitioner appellant lives in Guwahati with her children and not in house said to have been constructed by power of attorney holder on part of the land acquired by state government. For reasons discussed above, the appeal is dismissed as no order to the cost. May Lord kindly see the next page. Now, next page. The SLP was challenged by the power. The SLP was filed by the power of attorney holder before the Honorable Supreme Court, and SLP leave was granted, but SLP is dismissed with the observation that in case Honor files the special leave petition, dismissal of this petition shall not affect him adversely. Honor did not file the SLP, so therefore the order of the division bench, my lord, attained finality that the land will be acquired under the old act and land has been acquired under the old act. Now, one more development has taken.
Anyway, Mr. Admiral, since yes, this is matter for any bench or me. Yes.
Lordship, this is a modus operandi which I really because
I'm sorry, Your
because
Lordship.
of that only, my lord, because of that only matter went before this, and this is under the old act. They have done it, and now what I saw that the compensation has been determined by my officers under the new act, which they could not have done it, and there was no lapsing of the acquisition proceeding. So I understand, but I'm advising after going through.
My hands are tied.
I understand, my lord. Your lordship, I am covered by the Sahara judgment. Justice Keher has written, because in such cases, in that case also, the judgment was filed saying that the bench should recuse it, and the bench refused to recuse it despite the fact
in fact, you know, if the proper appraisal was done, the petitioner has no right. Has no right,
yes,
have no locus for
yes,
first.
yes,
It's
my lord.
just that
No,
the power
no,
attorney holder
I'm going
has somehow
to,
brought,
I'm going,
brought
I'm, no,
to
this
had
is,
brought
yes,
the
correct.
person in, you know, and so some of the rights.
And that is why these orders have been. Your lordship is now. Your lordship knows the fact, and now I have also.
Now I remember after seeing that order now. So I'm thankful to
yeah, and the matter was
for showing that order. So I remember because now I remember.
Now
yes,
I feel that in this case the investigation should be carried out. That is why I'm going to recommend.
Number 9.
In this will be a second case for now.
Obliged.
Lordship, the contemnors have filed the affidavit, Lordship. Now, so far as the main contemnor is concerned, Lordship, they had stated in the affidavit that they had issued us a show cause notice, Your Lordship, to participate in the inquiry. Lordship, our stand is that I have taken instructions, Lordship. The petitioner has not received any notice from the inquiry from the managing committee. It's contempt, Lordship.
Which order is it still violated?
Lordship, order dated 13/5/2024.
20?
13/5/2024 at page 8.
What does the order say?
Lordship, operative part will be 15, Lordship.
Yeah.
Paragraph 15, page 15.
Okay. This is by. When was it? When was the order dated?
13 May 2024.
13 May
2024.
In the results, so our commission is set aside and the matter is remitted to the committee detailed inquiry. You're the managing committee.
Yes, my lord. We have already
Have you started
conducted.
inquiry?
We have already started. Actually, it's stuck with the notice sent to the petitioner,
Where's
but
the
not
notice?
receiving notice. In my affidavit, page
Already concluded
50.
inquiry also?
No, not yet.
no, Lordship.
Only the
Then you
notice
take
sent to them.
part.
Let them take the notice.
That's
I'm just
that's
praying.
what that is the submission right now, Lordship. That let them issue a fresh notice because
Fresh
Yeah, we will
notice.
issue
Yes,
fresh
it is
notice.
submitted by Mr. Dokrut on behalf of the managing committee that a show cause notice had been duly issued to the petitioner, which is however denied by the learned counsel on instructions. So, be that as it may, as the inquiry proceedings have still not culminated, the managing committee is directed to issue a fresh notice to the petitioner and give an adequate opportunity. Yes, understand this proposal.
Lordship, there's another direction to the managing committee at para 15, Lordship, to release the salary, Lordship. I've not been paid salary from the year 2021.
Release the salary also.
Your lordship, of course the petitioner is supposed to receive the salary from me, but my pocket is empty because I have to receive from the government. The government has not received any money. Because it is from the government. No, it is from the government. No, your lordship. We're supposed to get from the government. The government has not received. No, we have not received. Let the government receive.
Absolutely incorrect, my lord. This is, my lord, the teacher is a deficit teacher, my lord. So
Let's see.
whatever
Then
they
where's,
receive granted
you
aid,
should
my
say
lord.
that, Ms. Nompir, at the outset, that the violation is that you're saying that show cause.
Lordship, there are three violations, Lordship. One is salary, the second part is inquiry, and the third is regard to the disposal of the representation, Lordship. Para 15 talks about the salary, Lordship.
Where it is further made clear that in case the government is willing to induct petitioner, has to give up her back wages.
Lordship, can you see para 15, Lordship, page 15. Para 15.
You pay the salary, otherwise we'll hold you up for contempt.
I will seek instruction, and I'll address them. I will tell them whatever is required, your lordship.
There's an order of the court to approve.
Yes, your lordship.
They'll go to jail.
Actually, I've seen instruction from them. They said they didn't receive any money. They didn't receive money from the government.
Oh, if there's consent on instructions. Yes. Stop.
The order that you have given that is required. Yeah.
It's not culminated. Yes. It's not concluded. Yes. You do issue fresh show cause. Allow. But then the next paragraph. It is further submitted by the learned counsel for the petitioner that this court had directed that till completion of such inquiry, the managing committee was to pay the salary. So up to this, Mr. P. Dokrut submits that they are ready to pay the salary, but
we have not received from.
They are short of funds.
And we have not received.
Receipt of the.
We have not received any funds from the government. Supposed to pay to them.
They are short of funds as they have not received the same as yet from the government.
My lord, she is a teacher appointed by the school managing committee.
But she's a deficit.
Yes, my
deficit.
lord. The school is a deficit school.
Deficit.
She's a teacher appointed by the managing committee.
Even though it's a contempt matter, he prays that he allowed to obtain SC instruction. This is the matter after 10 days. Otherwise, then you have to pay. Within 10 days, you do whatever you have to do. You don't sell the school, that's all.
Much more.
10.
Yes.
Please, Lordship, I'm sincerely apologetic on the last occasion, Lordship, due to certain circumstances we could not appear.
So there's no contempt?
Lordship, the matter is under consideration as
observed. Actually, what's happened is that the concerned officer is on leave. We are just drawing up a settlement agreement. Another 2 weeks, we should be able to finalize it.
Yes, list up to 2 weeks. The
Published.
11.
Lordship, I'm appearing on behalf of Mr. D. Thaime on this matter. D. Thaime.
D?
Thaime.
Who D. Thaime? Oh, petitioner?
Lordship.
Yes,
Lordship,
you joined her. Before you joined her.
Lordship, I'm seeking for
Have you
some more
filed it?
time.
How many times you sought?
Second, Lordship.
Is further 2 weeks time as per allowed for joinder just thereafter.
12.
Filing today? It's for affidavit. We are filing today, madam.
Mozita and National Council also submits that affidavit on behalf of the respondents 8 to 10.
8 to 10.
11? 8 to 10 will be filed within 2 days, yes. Similar prayers made, similar submissions made by Ms. Akas.
Your Lordship, on behalf of the state, I'm waiting for 1 week's time.
Oh, you haven't filed?
No, Your Lordship.
Let's score it out. Ms. MSZ Inokandi for response 1 to 7. Provian Mozika for 8 to 10. Ms. Akas for 11 pray for loud 1 week for a time to file affidavit. This thereafter for further orders.
Item 13.
13 is for rejoinder.
For rejoinder. Who's for the petitioner?
Mr. B. Dev.
You're for the petitioner? When have you won't file rejoinder? You won't file?
For 3 weeks' time, Your Lordship.
No, 3 weeks time. How many times you pray for rejoinder?
Sir, 2 times, Your Lordship.
Final opportunity of 2 weeks allowed for rejoinder affidavit. Just thereafter for hearing. Yes.
14.
I know we're supposed to file the rejoinder, but 1 week's time will be given, Your Honor, to file the rejoinder, Your Lordship.
Have you filed a fresh copy?
We've given a copy.
Yes, Your Lordship.
Dr. M. Mozeka submits that pursuant to the order dated, submits in compliance with order dated 31/1/2025, a fresh copy containing the particulars of the names shown in Lecture B of the affidavit have since been supplied. Therefore, MSR, we are hungry.
Yes, Your Lordship.
For the petitioner prays for how much?
1 week's time, Your Lordship.
1 week for the time for the joinder. Prayer allowed list around.
15.
Please, Lordship. Lordship, I may be allowed 2 weeks' time to file my rejoinder, Lordship.
Yes.
Rejoinder affidavit, Lordship, to the
Mr. T. Dakhar prays for about 2 weeks' time for joinder.
16.
Yes.
Lordship, in this matter, we are supposed to file the rejoinder, Lordship. Lordship, we are filing it in the course of the day, Lordship, today.
Yes, sir.
And for 1 and 2, Your Lordship.
So, your food for leaking? Yes, sir. No, don't talk into. How today you're filing?
Lordship, in the course of the day, we are filing
the agenda for the writ petition. Submits that affidavit rejoinder, we file the fourth with the list for hearing after
3 weeks, Lordship.
After 3 weeks.
Lordship, interim order may be extended till the next date, Lordship. I'm praying.
Item 17.
May I please, Your Lordship? Your Lordship, in this matter, we have communicated one letter to the petitioner, Your Lordship, for her to submit some documents.
You filed affidavit?
We already filed.
What did he say in the affidavit?
Your Lordship, as per the affidavit, Your Lordship, it seems that the matter, they are waiting for the cancellation of the old PPO, Your Lordship.
Your Lordship, that has been done.
The dispute is
We
that
just-
she's entitled to family pension. There's no dispute, Your Lordship.
We just need some documents for her to submit new documents, Your Lordship.
The other direction for her some documents. What if you send an affidavit? Can it be closed now? The matter?
We have communicated her
So the pension
letter,
matter,
Your
it can
Lordship.
be closed. The earlier the better. Yes.
Your Lordship, we're just waiting for.
From her side or from whom?
No, from
the
the
CPO.
from Delhi, Your Lordship, from New Delhi, and for her to submit new documents, Your Lordship, for the petitioner.
You've got instructions to submit new documents.
No, Your Lordship.
Then
This is a
the
letter, Your
affidavit
Lordship.
is incomplete.
Your Lordship, this letter was sent after we filed the
Let's see. I'll give a copy to her.
Your Lordship. We already sent you the petition.
It's addressed to her only.
Yes, Your Lordship.
Okay. Ms. Ivy Prasad, then the counsel for the respondent number 2 has produced a communication dated 14/2/2025 addressed to the writ petitioner with regard to the a family pension case. Case wherein certain requirements have been indicated. Stop. He prays that the matter be taken up after
2 weeks,
after
Lord.
3 weeks, yes, to enable the petitioner to comply with the requirements. Oh, no, you prays for 2 weeks, yes, stop. MS has hearing on behalf of the petitioner. What was your submission?
We have not received, Your
You have
Lordship,
received
this
it now?
letter. I've just
Was
received now.
receipt of the was been handed a copy, prays not to obtain the instructions. It's up to 3 weeks, yes.
Highly obliged, Your Lordship.
18.
There are three matters, 18, 19 and 37, my lord.
Yes.
Now, so far as item 18 is concerned, my lord, all three matters are filed by the same petitioner, my lord. 18, 19. In 18, if your lordship will see kindly the prayer at page 20, this petition in this form, in my humble submission, may not be maintainable. There has to be two writ petitions separately, my lord. If your lordship will kindly see page 20. Page 20 where prayer is, my lord. MTAT certificate dated January 2022 of the private respond number 8. So, setting aside of the MTAT certificate of respond number 8 has been sought, my lord.
Yes.
Separate prayer, my lord, because, and then, my lord, set aside the notice dated appointment letter of respond number 8 to 15, my lord. So 8 to 15 appointment letters have been saying that their degrees are not valid and probably, so for respond number 8 to 5, and the for private respond number 8, my lord, MTAT certificate is also being, so separate relief, independent relief is being sought. For respond number 8, separate writ petition should have been filed because his writ petition cannot be clubbed. Because so far as the grievance of respond number 8 prayer 2 is concerned regarding their TET certificate obtained from Assam, my lord, as state of Assam is a party, but they, all these two prayers have been clubbed into one. It has to be separate. After this writ petition, my lord, the item 37 does not survive. Why? Because the item 37, my lord, they have sought the same relief in the sense that in 37 relief is with regard to not issuing the appointment letter to the teachers. Appointment letters have already been issued, and now in the fresh writ petition, the
appointment of those teachers.
The same teachers, they are being checked.
Lordship is in the other court, Lordship. Some part of hearing is going on, Lordship. So, Lordship, actually, this
because
matter
the 37
was
has
steps,
to go.
Lordship, and we've already taken steps. Fixed for steps, Lordship. We've already taken steps, Lordship. We've already taken steps in the last occasion, and in the other matter, Lordship, we have already obtained the service report, and the reports are showing that the service have been delivered, Lordship.
One respondent on the private respondent.
On the private respondents.
And the third matter?
And Lordship, the third matter is
becoming infructuous in my
hearing, Lordship. This is the first matter.
In my opinion, because the prayer is prayer in 18 and 30.
Let Mr. Chariso come. All again.
20.
And item 42 are connected, my lord. 20 and item 42. In 42, we have filed the reply, and item 20, we are seeking some more time to file reply in this matter, my lord. 2 and 20, my lord.
This is that.
That the student admission of students in PS Sangma Medical College.
Infructuous now, since they have made the concession that they'll reduce number of seats next year, and all of them can pursue.
Only issue is, my lord, the NMC, because as a NMC may be party, because the intake capacity cannot be increased beyond the regulation, because if the intake capacity.
Are they a party here? Medical council?
Yes,
they are appearing.
Yes, I don't think they are party here, because without.
We are a petitioner in this item number 450. We are a petitioner.
And NMC has been made party, my lord. National Medical Commission is a party, my
Oh,
lord.
you are, mister? Who's your senior? Who's this?
From Delhi, my lord. National Medical Commission is a party, so their reply would be required.
Yeah, you are there. Respondent number 2, National Council.
Yes.
Oh, yes. It is submitted by the Advocate General on behalf of the state respondents 4 and 5.
4, 5, 4, 5.
4 and 5 only.
4 and 5 only, my lord.
4 and 5 that the respondent
3, 4, 5. 3, 4, 5, my lord.
3, 4, 5. That the respondent number 2, National Medical Commission inputs are necessary in the incident matter. So are you appearing for National Medical Commission? No, you are appearing, Dr. Mozika?
Only for one,
As
number 2,
but they've been served. When were these served? Inputs are necessary. Though it is indicated in the office note dated 11/2/2025 that they have since been served, no appearance is made on their behalf today. Stop. We'll list it after 2 weeks. This is the matter after 3 weeks. Yes.
42 also, my lord, because 42.
Enable appearance of one number 2. Yes. 42 live together with one.
21.
In this matter, Lordship, the respondents were supposed to take
Who's
instructions.
the Carnatic Council for in this matter? For the state?
Lordship, as per the last order, Miss R. Conley.
No, I mean before that. Because,
My lord, J. Khaba, my lord. I appeared in the last occasion because there was no one here, my lord. Lordship has called upon.
he's not here today also.
My lord, another way, my
I think you reassigned the case, Mr. Advocate General. This is, I mean, the poor fellow, I think he has some health problems.
My lord, I don't know.
Yes, it's noted that the learned, so the matters adjourned on 19/2/2025 due to his non-appearance is not available today also. So the Advocate General says that appropriate action will be taken in this regard just after 1 week.
22.
My lord, 22 to 29 are those, and 41, my lord, is the lead matter in this matter. 41.
Will be taken up today, Mr. Sapa? Yes.
Yes, my lord. Because, your lordship, I am having a stay, my lord, and they have said that they will argue the matter, my lord.
So no, Mr. Tiwari has come also from Guwahati.
So therefore, my lord, kindly hear item 41, because that is, your lordship has always held that it is a lead matter in this.
Now, whether 41 or whether our case, the point of law is the
same in all matter. Point of law is same in my.
By saying that take up item 41 first makes no sense.
Why it makes sense, my lord? Why it makes sense, my lord? Let me point out. Because your lordship's order has been that the matter in item 41 is the lead matter. That is the, because of that I am ready to argue all the matter. So that is why it is making a sense. It is making sense because of that only. It is making a sense.
Mr. Tiwari, before you all get agitated before the argument start also. So let us, have some calm. And so the thing is that we are not addressing any issue, we are addressing what point of law. So that it's common to all the cases.
Yes,
so
that's
other
it.
Cases,
so whether it is 41, whether it is 39, doesn't
refer to the fact certain cases.
Yes, so it hardly makes a difference.
Where all the materials are present in particular case, we'll take that up first. Which one is that?
Here, all the horses are same. So which horse is first doesn't make a difference. Whether 23 is before 41 or whether 41 is after 23. So let that 23 be taken up, my lord.
Your lordship, because everything is there in 41, my lord. Everything is there in 41.
Tariff order is not there in 41, but in any case, the most important issue, which involves all the writ petition.
Let us first, look at the issues. What are the
That's
issues?
it. I'll place
The
it.
very simple issue is that, if I correctly remember, there was an order passed by the Regulatory Commission, which was reviewed, correct? And now your challenge is that the Regulatory Commission does not have the inherent power to review.
I'll put it in
That's
one
what-
line.
yes.
I'll put it in one line. The only issue is as to whether or not the commission which issued the order on 6th of June had a jurisdiction. If the commission which issued the order on the 6th of June had a jurisdiction and the order dated 6th of June is a legally correct order, nothing survives.
Right.
And I will satisfy my lord on that point, that the commission acted legally within the jurisdiction in issuing the order dated 6th of June.
Yes, my lord. Now my friend has crystallized the this is my so let them argue the matter whatever they are.
Both my senior staff, my lord, I have a small prayer, my lord. Insofar as, my lord, the matters where Mr. Paul is appearing, my lord, I had a small prayer, my lord, that let 23, since learned seniors come from Guwahati, and today, my lord, it's, in all likelihood, the matter was supposed to be taken up. My lord, let my learned seniors start, my lord, and today I don't think the matter will be over.
It will be over.
It will be over.
My lord, I'm only praying, my lord.
I will not keep it too long also.
Mr.
because
Paul,
it's
my
a
lord,
matter of public revenue. So this court will endeavor to, conclude the hearings, not to pass a judgment maybe, but at least conclude the submissions.
My lord,
And whatever submissions
one more date may kindly be fixed, my lord, for
Then, the thing is
for
that it'll
for
cover
Mr.
your
Paul
claim
to
also.
supplement his argument, my lord, because my lord, I understand, my lord, we had committed that the matter will be taken up today. My lord, it was on the expectation, my lord, the morning period will be over by then. But it did not happen. It did
So,
not.
Mr. Thapa, it's adjourned to this day on your submission that alternate arrangements will be made
Yes.
also if
Yes,
necessary. So if those circumstances or contingencies were there, there will be alternate arrangements. Because then
But-
they have come from Guwahati.
My lord,
these are the,
that is why, my lord, in fact, I made an attempt to have a word with him, even to seek instruction, my lord. The situation as such, my lord, I couldn't even speak to him properly.
Okay, yes, we'll hear. Then we'll finish the arguments of Mr. Tiwari and.
My lord, one more date may kindly be fixed, sometime
We'll
as
hear
per
you.
your lordship convenience. Well, we'll supplement.
Let me start my argument and let us see how it develops. May it please your lordship.
Go to
No, my
item
lord.
23. Your item.
Yes, 23.
Okay. Since it's item 23 and update 23.
Now, since my lord, in all the writ petition,
41. Yes. 1 second. Let the file come. Pioneer Carbide.
now my lord, the common thread which joins all the writ petitions is the order of the Commission of 23rd of August 2024. The Commission, by this very particular order of 23rd of August 2024, quashed, though they do not use the word quash, they use the word recall. They recalled the earlier order. The Commission recalled its earlier order of 6th of June. So the order of 23rd of August 2024 has got two components. The first, recalling of the previous order of Commission dated 6th of June. On the ground that the Commission which issued the order dated 6th of June had no jurisdiction to do so.
Yes.
It was without jurisdiction. Therefore, acting on a premise that the order dated 6th of June 2024 was without jurisdiction, the Commission, by 23rd August 2024 order, sought to recall the order without jurisdiction, that is 6th of June.
Yes.
It is a different matter, though one may very well say, if the order is without jurisdiction, it is a nullity, so no question of recall of the order. Now the second issue, my lord, is as to whether the Commission has the power to recall its order.
Yes.
Now, my lord, so far as second aspect is concerned, my arguments are going to be very, very limited.
Yes.
My endeavor would only be to demonstrate before my Lord that so far as the inherent powers of the Commission is concerned, I have no quarrel with the inherent powers. I would presume that the Commission has got the inherent powers. So far as the power of review is concerned, it is there embedded in the Act itself. There is a power of review. I would also accept the very contention that Commission has the inherent power. The question would be as to whether the conditions precedent
allowed for that.
Yes, whether the conditions precedent existed which allowed the exercise of the inherent powers. That is so far as the second aspect of the matter is concerned. Now, my Lord, to begin with, I would deal with the first aspect, namely as to whether the Commission which issued the order of 6th of June acted within the jurisdiction and as to whether the order is legal. If my Lord is satisfied on the first count, nothing would survive. Now, my Lord, the case has a background and the background would be necessary. The background under which the order of 6th of June 2024 was issued. Yes. So far as the background is concerned, my Lord will get the background in 8 paragraphs of the impugned order itself. That is the order of the Commission dated 23rd of August 2024. This is Annexure 9, page 105. I will start, my Lord, with paragraph 1 of page 105.
Yes.
The relevant portions I will read just to give the background.
Yes.
The utilities of Meghalaya, namely Meghalaya Power Distribution Corporation Limited, Meghalaya Power Transmission Corporation Limited, Meghalaya Power Generation Corporation Limited, filed 2 petitions for financial year 22-23 and multi-year such and such. Details are given. The Meghalaya Electricity Regulatory Commission, after calling for objections and suggestions from the stakeholders and issuing public notice in the newspaper, conducted the public hearings on 18th March 24, 19/3/24 and 20th 3/24. The matter was heard by the chairman and member law. The matter was heard by the chairman and member law. This is important. The two heard the matter. However, due to the ongoing model code of conduct, the order in the matter could not be issued on 11/5/24. They heard the matter, hearing was concluded, but they could not issue the order on 11/5/24 because of the model code of conduct. The chairman demitted the office due to superannuation. So, my Lord, chairman gets retired. He is superannuated. He demits the office. The order was finally issued on 5th June 24 for true-up 22-23 and 6th June 24 for approval of MYT ARR for 4th control period, financial year 24-25 and financial year 26-27 and determination of tariff for such and such. Since the chairman had demitted the office by then, the order was signed by R.K. Soni, member law. So the member law and the chairman heard the matter, hearing got concluded, model code of conduct came into being. In the meantime, the chairman got superannuated, demitted the office, then the member law, my Lord, issued the order sitting singly. Obviously, since chairman demitted the office, he could not have signed the order. So, my Lord, the principle that the one who hears must decide, in principle was not violated. The one who issued the order heard the matter also. It is a different matter though that the another person who was also the part of the commission could not sign the order because he demitted the office. Aggrieved by the order of the commission, para 2, the MEPGCL, MEPTCL and MEPDCL approached the Honorable High Court of Meghalaya via writ petition number such and such. So all public utilities came in a writ petition challenging the jurisdiction of single member who signed the order when both the chairman and member law heard the matter. So they both heard the matter. Together they could not sign the order. Only one signed the order. This was the core of the writ petition.
I'm sorry, may I take leave for 5 minutes? I will join.
Challenging the jurisdiction of single member who signed the order when both the chairman and member law heard the matter. It was also pointed out that Meghalaya State Electricity Regulatory Commission, under section it should be regulation, Because, my lord, in regulation, the provisos are addressed as regulation, not section. Regulation 18, sub-regulation 3 provides for signing of all the members who hear the matters. So the argument was that the regulation 18, sub-regulation 3 provides for signature of all those members who hear the matter. Since the two who heard the matter, one could not sign, therefore the order was without jurisdiction. Honorable High Court of Meghalaya by order dated 25/6/24, while issuing notice to the Commission, observed that prima facie matter deserves consideration and interim stay granted on the impugned orders of the Commission dated 5/6/24 and 6/6/24 until next date. The relevant extract of interim order is reproduced below. Not necessary, I will skip it. The interim order, entire interim order is quoted. Then para 4 of the order of Commission. This is, I am reading from 23rd of August order of the Commission, which is impugned before my lord. The Commission made a statement verbally on 16th July 2024 that in case the Honorable High Court of Meghalaya allows, the Commission is ready to re-examine the cases. This is significant, my lord. That, though, my lord, I would not be really emphasizing very hard on this issue, but this shows the unholy nexus between the public utilities and the Commission. It is the Commission has behaved as if applications were filed, so that is why Commission re-examined the matter. The intention of the Commission in the beginning itself was, Commission was over-eager to examine the matter. The Commission made a statement verbally on 16 July 24 before the Honorable Court that Commission is ready to re-examine the cases. The utilities of Meghalaya meanwhile prayed for withdrawal of writ petition. They arrived at an understanding. So Commission would re-examine the matter, public utilities wanted to withdraw the petition. So the Honorable Court permitted the utilities to withdraw and re-agitate the matter afresh before the Commission. That is how, my lord, from the Honorable Court, the matter went to the Commission. Now para 7. The utilities of the Meghalaya filed 6 numbers of interlocutory applications based on the orders of the Honorable High Court with the prayer to rehear the petition for such and such, such and such, such and such, the periods. Recall the earlier orders issued by the Commission and pending recall of order and also suspend operation of the order. So, below, practically the nature of the relief they sought for the public utilities are typically like Shivdan Singh's case, State of Punjab, the Constitution Bench judgment of the Honorable Supreme Court. Since the order was without jurisdiction of 6th of June, so recall the order, rehear the matter, pass fresh orders. Para 8. Based on the application filed by the utilities, the Commission issued notice for hearing on 12th August 2024. The industries, namely Barnihart Industries Association, approached the Honorable High Court of Meghalaya for stay of the notice issued by the Commission, stating that the Commission do not have jurisdiction for hearing on suo motu basis. The Commission informed the Honorable High Court of Meghalaya that it is not suo motu, but the Commission has issued notice on applications filed by the utilities. After hearing, the Honorable High Court of Meghalaya has dismissed the application on 8th of August 24, giving liberty to BIA, that is Barnihart Industrial Association, to raise their objections with the Commission. Extract, my lord, I will skip off. So, my lord, these are the 8 relevant paragraphs, and this is what, my lord, the background of the case is all about. So, the matter was heard, and after hearing the matter, this impugned order was passed. As I submitted earlier, impugned order has 2 components. Number 1, it was held by the Commission that the earlier Commission, which issued the order of 6th of June, acted without the jurisdiction. Order had no jurisdiction. It was a nullity. And order was recalled, the second part. Now, my lord, thereafter, straight away I will come to the issue which Commission framed for itself and analysis of the issue. That, my lord, starts at page 122 of this very order itself. Yes. Paragraph 43. Para 42. I'll start, my lord, from, let us begin with para 43 straight away. My lord will come to para 43. A and B.
Yes.
We have conceded the rival submissions of the councils. Before that, all the arguments have been, my lord, taken note of. We have considered the rival submissions of the council and filed two relevant questions which need to be addressed. A. Did the commission have jurisdiction while issuing orders dated 5th and 6th June 2024 for such and such? Whether the commission can recall the orders issued as above and rehear the petitions afresh. These were the two issues. Now, my lord, the jurisdiction. I will read the portion and thereafter, my lord, I will give my rebuttal as to where commission had gone wrong. On the issue of jurisdiction, how the commission has approached. To me, my lord, it was an eye-opener when I started reading it. It is an exercise, my lord, in selective reading of the provisions of law.
Section 92.
Yeah. My lord, it starts page 123, paragraph 44 onwards. Before going into the above issue, para 44. Yes. Before going into the above issue and submissions made by the learned counsels of both the parties, let us go through the relevant provisions of the Conduct of Business Regulation of the Commission and Electricity Act 2003. It's interesting. So, my lord, para 45, the Commission quotes section 92 of the Act. Now, as to why it has chosen to quote section 92 of the Act while referring to the regulation, I will straight away take my lord to the regulation and section 92. Side by side, I have to show that.
I'll see.
Because, my lord, there is a purpose why commission has followed a particular pattern.
Yes, yes.
In coming to a certain conclusion. Because, my lord, the saying in law is, if you decide beforehand that this is what you are required to achieve, you follow a particular pattern. Now, my lord, let us straight away turn to the regulation first. The regulation, my lord, will find Annexure 4, page 38 of the paper book. Meghalaya State Electricity Regulatory Commission, Conduct of Business Regulation 2007, Annexure 4, page 38. My lord, will see the recital. In the very beginning, in the top itself, in exercise of the powers conferred by section 181(2)(ZL, exercise of the powers conferred by section 181(2)(ZL, read with section 92(1) of the Electricity Act. So, my lord, this regulation has been made in exercise of power under section 181(2)(ZL and 92(1). Now, let us turn to, my lord, straight away 181(2)(ZL of the Act, Electricity Act. Now, section 181, my lord.
Rules of procedure.
My lord, Electricity Act.
Yes.
Yes. Section 181.
Yeah.
Section 181, 1 also I will read. Subsection 1. The State Commission may.
Yes.
It's the power of the State Commission. The State Commission may, by notification, make regulations consistent with this Act and the rules generally to carry out the provisions of this Act. So, my lord, subsection 1 is very widely worded. It clearly says, it mandates that Commission is empowered to make regulation to carry out the provisions of the Act itself. Now, my lord, if I am a Commission and if I am wise enough, simple thing I will do is, I will simply say that in exercise of power vested in me under section 181 subsection 1, I am making the regulation. They chose not to do that. Instead, what they did, 181 subsection 2, Lordship may see. In particular, and without prejudice to the generality of the power contained in subsection 1. So, without prejudice, in particular, without prejudice to the generality of the power. It's a general power, but without prejudice to that. Now, in subsection 2, such regulation may provide for all or any of the following matters. Then, my lord, distinctly the matters are there. They did not refer to any of the matters. They straight away chose to refer to one particular matter, that is, please kindly give my book. I'm more comfortable with that. I have my markings. Keep it properly. Huh? That will be difficult. Keep the books properly, please. I'll read. That's why I was wondering how come the act is looking so different, because I had my notings and markings.
Happens. Yeah.
Now, my lord, ZL. Rules of procedure for transaction of business under subsection 1 of section 92.
Yes.
Rules of procedure for transaction of business under subsection 1 of section 92. Now, my lord, may turn to 92.
Proceedings of appropriate commission.
Proceedings of appropriate commission.
Yes.
Subsection 1. The appropriate commission shall meet at the head office or any other place at such time as the chairperson may direct, and shall observe such rules of procedure in regard to the transaction of business. Where? At its meetings. And my lord, interestingly, regulation defines meetings also, including the quorum. Where? At its meetings. So the quorum, it talks about at its meetings.
So they are free to specify the quorum themselves.
Yes, as it may specify. Then subsection 2, such and such. Then comes, my lord, subsection 2, subsection 3, 4, 5, all, my lord, deals with the meetings. And it is proceedings of appropriate commission. Interestingly, I will further elaborate my argument when I deal further with this. But I am just giving an indication to my lord. My lord will see another thing. Section 95. Proceedings before commission. Section 95, proceedings before commission. Section 92, proceedings of appropriate commission. It is of, there it is before. Likewise, I will deal with this. I have given an indication. Proceedings of and proceedings before. My lord, the present proceedings are before the Honorable Court. I am going to develop this argument. Yes. The proceedings, my lord, of the full court in the administrative capacity will be the proceedings of the Honorable Court.
Of the court. Okay.
I will deal with this further.
Yeah,
but I have given this indication.
On that. Authorities now. You're going to the root of the matter by saying before and of.
Not only this, there are other aspects also, but this is one indication.
Because what you're trying to say is that the entire proceedings of jurisdiction, when they
even
ventured to re-examine it.
Yes, and my lord,
forget about the order of 20.
Even the appellate, my lord, even the appellate tribunal, the larger bench of 3 members, thought likewise. I will deal with that also. And I will also deal with the gross judicial or quasi-judicial indiscipline on the part of the appellate tribunals. There are contradictory orders of the appellate tribunals. 2 orders, 1 voice, other 2 orders, another voice, and then there is a direction of the 3-member commission, 3-member appellate tribunal, which takes precisely this view. No quorum is necessary. I'll deal with all that. I'll deal with all that. So, my lord, this is what it is. Section 92. Then, my lord, now I'll come to the reliance was on 18. I'll just straight away. I digressed. I'll come to, my lord, the commission itself. How it approached. I was reading, my lord, paragraph 43.
You were at the regulation at
para 43. I was reading, my lord, at page 122. Page 123. I'll turn to.
Yes, 45.
Yes, so 45 I will skip now. Entire thing has been quoted. Then 93, section 93 they have quoted, which is interesting. The commission has quoted section 93 at the bottom of para 45. It doesn't discuss the significance of section 93. I will read this at least. Section 93, vacancies. Vacancies not to invalidate proceedings. No act or proceedings of the appropriate commission shall be questioned or shall be invalidated merely on the ground of existence of any vacancy or defect in the constitution of the appropriate commission. Well, Lord, I am only giving an indication right now.
Yes.
I am going to argue on section 93 that this section 93, my Lord, is very wide and openly worded. It includes both of the proceedings and proceedings before the commission. That is, proceedings of the commission and proceedings before the commission. Section 93 includes both. Vacancy, whether in the case of, my Lord, proceedings of the commission or before. Now, my Lord, thereafter, para 46, there is a discussion on section 92, subsection 1. Conduct of business regulation, referred.
Quorum? Yes.
Then, my Lord, Regulation 8. This I will read again. Regulation 8. Sorry, it's okay. Regulation 8. This Regulation 8, my Lord, will find.
You can read it from here only, 124.
Yes, just a minute. Proceedings of the commission.
Yes.
Regulation 8 talks of proceedings of the commission. All hearing, examination, inquiries or consultation held or conducted in a meeting. Again, the word meeting is very significant. Shall be deemed to be the proceedings of the commission. A matter shall be heard or considered by the commission in a meeting. Apparently, my Lord, one can't argue this is the meeting of the Honorable Court. This is not. The commission, while hearing or considering a matter, may, if it considers it necessary to do so, co-opt an officer of or any person possessing knowledge of adequate such and such experience in a particular field to be present and take part in the meeting. By such officer or person shall not have the right to vote such and such. Since they are talking of meetings, so vote naturally will come. Then Regulation 8, Regulation 4. All proceedings before the commission shall be deemed to be the judicial proceeding. Now, my Lord, so far as Regulation 8, Sub-Regulation 4 is concerned, it is pari materia to Section 95, which I read, of the Act itself. They have brought in here. But they clearly, my Lord, the whole thing is pari materia to Section 95. So, that way in the regulation itself, my Lord, we see the discordant notes in between the provisions.
So, before and off are mixed
This
up.
is one aspect, very, very significant aspect.
Yes.
Then, my Lord, I rather read, otherwise, my Lord, I'll keep on digressing myself, but I thought that it is important if I just indicate some of the important aspects. Just a minute, 123. So, para 46 is gone. Then, my Lord, Regulation 10 they have quoted with regard to quorum. Then again, my Lord, quorum, here itself I read. Quorum, my Lord, it's again the business regulation. Regulation 10. Where the commission has also one member or more, the quorum of any meeting shall be 2, including the chairperson. Regulation 18. Decision and orders of the commission. 1. On completion of a hearing or consideration of a matter, the commission shall give its decisions with reasons therefore and shall pass orders, including orders with regard to cost. 2. The commission may also pass interim orders as may be necessary from time to time. 3. All orders of the commission shall be signed and dated by the chairperson and members hearing the matter and shall not be altered except to correct any apparent error. 4. In any proceeding, the decision taken by the majority shall be the decision of the commission, and in case of dissent, the dissenting member shall give his views separately. Then para 47. In view of Regulation 18, Sub-Regulation 3 of the COB regulations, it is evident that all the orders have to be signed by chairperson and members hearing the matter. It must also be borne in mind that as per Regulation 18, Sub-Regulation 3 underscores the importance that members who heard the matter are required to sign the order.
Yes.
The regulations framed by the Commission are in consonance with the governing law on the subject, and this is borne out of the following. The Honorable Appellate Tribunal for Electricity rendered a judgment dated 10th January 2019, passed in appeal number 901 of 2018, titled as Damodar Valley Corporation such and such, reported as 2019 SEC Online APTEL. So Damodar Valley has been referred. Then the very next, my lord, they refer to yet another order of the Central Electricity Regulatory Commission cannot be sustained. In this case, it was argued, Damodar Valley is being explained in next para. In this case, it was argued that the order in question passed by the Central Electricity Regulatory Commission cannot be sustained since the matter was presided by 4 members while the order was passed by 3 members. Regulation 2 of the CERC, Conduct of Business Regulation 1999, is stated as follows. They refer to the Regulation 60T of CERC. So on that basis. Then, my lord, the next, after considering the relevant question, the Honorable APTEL set aside the order in question passed by CERC. So, my lord, Damodar Valley in extenso they are referring to because it favors them. I will deal with Damodar Valley. I will skip, my lord, the entire quotation is there from Damodar Valley because the regulation of CERC was there. Then, my lord, thereafter they have referred to another judgment of the Appellate Tribunal, that is the Jindal case. The same, my lord, the same principle is reiterated like that of Damodar Valley. That yes, there is a requirement of the quorum. The members who hear it, all of them have to sign it. This is the, my lord, line they have taken. Then comes the para 5. Then they refer to Gullapalli Nageshwar Rao case and Rashid Javed case. Para 5. It is noteworthy that the Jindal case was passed by the Honorable APTEL on the strength of the decisions of the Honorable Supreme Court in Gullapalli Nageshwar Rao versus Andhra Pradesh State Road Transport Corporation and another. And Rashid Javed, that a person who hears must decide, and the divided responsibility is destructive of the concept of judicial hearing. Now, my lord, nobody can have a dispute with this principle of law that Gullapalli and Rashid Javed are concerned. In Gullapalli, just, my lord, I am giving certain indication. What happened in Gullapalli? In Gullapalli, my lord, Mr. X, who ultimately approached the Supreme Court, he was a private entrepreneur. He had a automobile business running buses. Now, my lord, the route of the bus was nationalized by the Andhra Pradesh government. The route of the bus was nationalized. So hearing was needed to be done. Hearing was required. So he was heard by Secretary Transport on the issue of nationalization of the route of his buses. Hearing was done by Secretary Transport, but the decision was taken by the Chief Minister. It was on those facts the Supreme Court said, if the Secretary Transport is not deciding the matter, he giving the hearing is of no consequence whatsoever. So person who hears must decide. So far as Rashid Javed is concerned, my lord, similar, absolutely similar. There, my lord, there was a modification. Again, there was a policy of nationalization of the routes of the buses in the Rashid Javed case also. And there was a modification of that very particular policy. Again, the person who did the hearing, he had no power to modify. When he had no power to modify, the Supreme Court said it's an issue of the divided responsibility. So far as, my lord, the present case is concerned, it is not a case that the person who has issued the order did not hear. He very much heard. The issue is the 2 persons heard, but one signed it.
1 person passed the order, yes.
Thereafter, series of, my lord, different orders, practically then para 7. Again, my lord, in para 6, they have referred to another judgment of the tribunal, APTEL, in global energy. Same, my lord, global energy also the same view like that of Damodar Valley and the Jindal case. Then judgment of Supreme Court is referred to, again absolutely no relevance in the present case. That is para 7, Roman 7. The Honorable Supreme Court in Pandurang and others versus the state of Maharashtra, 86 for SCC 436 has observed that an order passed by the single judge bench which was to be decided by the division bench of the High Court was a nullity. Naturally, below if the writ appeal is heard by a single judge and not by the division bench, one may very well say. Similar observations were also made in Bhargav Krishna Patil versus State of Maharashtra, etc., etc. Absolutely no relevance. In addition to the aforementioned, strength can also be drawn from the judgment of the Honorable Supreme Court in United Commercial Bank Limited versus Workman, relevant para 8. The Honorable Supreme Court in this case took note of section 16 of the Industrial Disputes Act 1949, relevant para 7, which required that the award had to be signed by all members, and held that if the award is not signed by all members, it will be invalid, as it will not be the award of the tribunal. Again, my lord, the facts are entirely different. Bank Limited versus the Workman 51 SEC online. I don't know. It is a case of an industrial tribunal. It is an award. I mean, absolutely, my lord, thoroughly misdirected itself, my lord, that commission. Similarly, reliance is also placed on the judgment of the Honorable Supreme Court in Karnal Improvement Trust versus Prakash Vanti, wherein it was held that when a public duty is imposed upon and a statute requires that it shall be performed in a certain manner, Taylor versus Taylor principle, my lord. If a thing is to be required to be done in a particular manner, it has to be done in that manner or not at all. It's a double-edged sword. I will show they were required to do thing in a certain manner, they did not do it. It can be seen, para 49, it can be seen that conduct of business regulation 31 sub-regulation 2 of KERC, sorry.
Yes, continue.
They are referring to Kerala Electricity Regulatory Commission. We don't know the nature of regulation, we don't know under what regulation were made, we don't know anything. Out of context, they are just whatever comes to their, whatever suits them, they are referring to it. It can be seen that the conduct of business regulation 31 sub-regulation 2 of KERC, Kerala Electricity Regulatory Commission, regulation 20 sub-regulation 1 of OERC, and regulation 18 sub-regulation 3 of MSERC are akin. So they say it's perimeteria, and require that the members of the commission who heard the matter shall sign the order. In view of the aforementioned, it is clear that the members who hear the matter must pass the order. Para 50. We have gone through the submissions made in case of OP1 of 2011 order dated 2/12/2013. Now, my lord, actually this is very significant. That is why they were required to deal with it. And I will show how they dealt with it. Yes. This is, my lord, they are referring to 2/12/2013 is a direction of the 3-member commission, including the chairperson.
Yes.
In its application is relied on the order dated 2/12/2013 passed in OP number 1 of 2011, wherein inter alia following has been held. 11. In our view, since the quorum depends upon the number of members in the office, even single member of the commission, including the chairperson of such a commission, can conduct the proceedings of the appropriate commission. 12. Therefore, we direct that all the commissions concerned, irrespective of the regulations with regard to the quorum for a meeting, that commission, even with a single member, despite that there are vacancies of other members or chairperson, can continue to hold the proceedings and pass the orders in accordance with the law. 17. We also deem it fit to direct the commissions to amend the regulation if any. So 11, 12 and 17. These 3 paragraphs, my lord, from the direction of the 3-member bench commission they have referred to. To suit their convenience, even my lord, these paragraphs would not suit them, I will demonstrate. And I would also read other relevant paragraphs which they conveniently left out. Then paragraph 51. It is observed that the directions issued by Honorable Aptel in its judgment dated 2/12/2013, it should be, my lord, not 23. It's a typographical error. 2/12/2013 in OP1 of 2011 pertains to the issue of proceeding of the commission in case of vacancy. Proceedings have been defined in Regulation 8 of Conduct of Business Regulation issued by the Commission as under. Then, for the purpose of proceeding, they refer to Regulation 8. 1. All hearing, examination, inquiries or consultations held or conducted in a meeting shall be deemed to be the proceedings of the Commission. A matter shall be heard or considered by the Commission in a meeting. Other things they have left. I will deal with Regulation 8 also while making a submission. Then, my lord, the next page. Then, interestingly, the Commission, my lord, here, it has given its own understanding and analysis of the 3-member direction of the Aptel 2/12/2013, because it doesn't suit them, but they were hard pressed, so they have given their own understanding of the order. This I will read what is their understanding.
Yes.
Bare perusal of judgment dated 2/12/2013, page 129. Bare perusal of judgment dated 2/12/2013 in OP 1 of 2011 would clearly reveal that merely because of vacancy in the commission, it should not stop hearing the cases. Section 93 of the Electricity Act 2003 also provide that if there had been any vacancy in the commission at the time of hearing the matter, or there had been any other defect in the constitution of the commission to hear the matter, the same cannot be made ground to question the order passed by the commission. However, the issue as detailed in paragraphs above were not the subject matter of decision. Now they are trying to distinguish it. However, the issue as detailed in paragraphs above were not the subject matter of decision in OP number 1 of 2011. So, possibly that commission is trying to argue that so far as APTEL is concerned, if that was not the issue before the APTEL ought not to have made these observations. Commission has taken upon itself as to whether the commission can do that. I leave it to my lord to decide whether commission is empowered to go to such an extent.
Yes.
We are not the subject matter of decision in OP number 1 of 2011. In the present case, at the time of hearing the matter on the true-up petition and MYT petitions, the quorum of the commission was complete. The quorum of the commission was complete, they say. And the proceedings were continued and hearing was concluded by the chairman and member law. Problem arose only when the commission pronounced the order wherein one member only signed the order as the chairman demitted his office by this time. Therefore, the judgment of the Honorable Tribunal is not applicable to the facts of the present case. So, on that basis, they say that whatever the Tribunal has said, it's not applicable. It is to the contra. I will demonstrate it is very much applicable. The Honorable Supreme Court in Punjab National Bank versus R.L. Ved, 2004-7 SCC 698, relevant para 5 has held that there is always peril in treating the words of a judgment as though they are words in a legislative enactment. And it is to be remembered that judicial utterances are made in the setting of the facts of a particular case. Very convenient, naturally, because they will rely upon this if it doesn't suit them. If it suits them, they forget about this very dictum. So, my lord, I sum up. So far as the commission is concerned in its impugned order, dealing with the various facets on the issue of jurisdiction, the following were the findings, how it proceeded. Number 1, it referred to regulation. Regulation, it referred to 92. It said very clearly that regulation is made under section 92 subsection 1 of the Act. It conveniently ignored section 181 2ZL. It also conveniently ignored the fact that section 181 subsection 2 has series of subjects. Of all the subjects, commission chose for itself 2ZL. One would argue, should not the regulation is required to confine itself to the subject for which it was made? This is one facet of the argument which I may make. Because regulation is made under 181 2ZL. Then, my lord, secondly, section 92 it relied on because it talks about the quorum, transaction of business in a meeting, etc. Because of that, it goes into the regulation. So, two things are linked up, regulation and section 92. By linking the two, it tries to come to a conclusion that, look here, regulation talks about the quorum. Then thirdly, reliance on regulation 18 sub-regulation 3. Regulation 18 sub-regulation 3. Then refers to Damodar Valley, Jindal, both the judgments of tribunal which favors it. Talks about one who decides must hear principle. One who hears must decide principle. Gurla Pandi and Rashid Javed. And lastly, it tries to distinguish the direction of the 3-member bench of the tribunal, whose direction was binding on it, direction was inconvenient, it distinguishes it. This is the basis on which it comes to a conclusion that the commission which issued the order of 6th of June acted without the jurisdiction because the orders was not signed by both the members who heard the matter. Now, my lord, one by one I will give the rebuttal. My first submission is the concerned regulation of 2006, that is Meghalaya State Electricity Regulatory Commission Conduct of Business Regulation 2006, is made under section 181 2ZL. Read with section 92(1) of the Act.
Yes.
The general power to carry out provisions of the Act under section 181(1) has not been exercised to make the regulation. Has not been exercised. I will proceed on both the premise. What if the power would have been exercised under 181(1) itself? Then also my submission would be it would have made no difference. But explicitly, power has not been exercised under 181(1). Under 181(2) it has been exercised. Read with 92. Then, my lord, matters provided under Regulation 181 Regulation 2 do not include Section 95 of the Act or Section 94 of the Act may kindly be seen. My lord, we'll just see the subjects, specific subjects under 181(2) of the regulation. 181(2) of the regulation, specific subjects of the Act. 181(2).
Yes.
Sub-regulation 2 says, may provide for all or any of the following matters. Now, Lordship will see the list. A. Section 14. B. Section 15. C. 15, 16, 18, 18, 32, 36. These are all sections. 40, 40, 40, 42, 42, 42, 43, 45. Different subsections also they have referred to. 47, 50, 51, 52, 57, 59. Clause G of section 61. Determination of tariff under section 61. Details to be furnished by licensee, section 62. Interestingly, terms and conditions for determination of tariff under section 61 Z.G.D. also not been referred to. Details to be furnished by licensee such and such, not relevant. Then Z.H. Lordship may see, issue of tariff order with modifications or conditions under subsection 3 of section 64. They could have, they did not. Then Z.L. finally, it is only the rules of procedure. Nothing, Lordship will not find either 95 or section 94. None of the two, my lord, will find. Now, my lord, I turn to straight away proceedings before commission under section 95, 94 and 86. Lordship may see for a moment section 95 of the Act.
Yes.
All proceedings before the appropriate commission shall be deemed to be judicial proceedings within the meaning of section 193 and 228 of the IPC, and the appropriate commission shall be deemed to be a civil court for the purpose of section 345 and 346. This is, my lord, pertaining to the power of contempt and the forgery of document, etc. So for that purpose, number one, it will be judicial proceedings and it is a civil court. But when there are proceedings before the commission, then Lordship may also kindly see section 94. Powers of appropriate commission. Section 94 has not been referred to by the commission in its impugned order. Subsection 1. The appropriate commission shall, for the purpose of any inquiry or proceeding under this Act, have the same powers as are vested in a civil court under the Code of Civil Procedure 1908 in respect of the following matters. It's exhaustive in respect of the following matters. Summoning and enforcing of attendance of any person and examining him on oath, discovery and production of any document or other material object producible as evidence. C. Receiving evidence on affidavits. D. Requisitioning of any public record. E. Issuing commission for the examination of witnesses, reviewing its decisions, direction and orders. G. Any other matter which may be prescribed. Subsection 2. The appropriate commission shall have the powers to pass such interim orders in any proceeding, hearing or matter before the appropriate commission as that commission may consider appropriate. 3. The appropriate commission may authorize any person as it deems fit to represent the interest of the consumers in the proceedings before it. My Lord, Section 94 by submission is, Section 94 deals with those very powers of the Commission wherein the Commission acts practically as a civil court. These are the powers, my submission is, which Commission exercises in respect of the proceedings before the Commission.
Okay.
None of these powers, my Lord, my submission is, can be exercised in respect of the proceedings of the appropriate Commission. Proceedings of appropriate commissions are the proceedings which take place in regard to the transaction of business in its meetings. When there is a transaction of business in the meetings of the Commission, there are proceedings. Section 92 confines itself to those very proceedings. Nothing more, nothing less. The nature of power which is there embedded in the appropriate Commission under Section 94 are the powers which Commission exercise in respect of the proceedings before it.
Okay.
Counter argument may be, look, Section 93, vacancy is not to invalidate proceeding. Here, no act or proceeding of the appropriate Commission. If off, this is the meaning you put to off, then what about proceeding of the appropriate Commission in 93? To this, my Lord, as I have already submitted, Section 93 is open-worded. Very, very open. It is so sweeping, Section 93, it includes proceedings of both nature. Whether it is proceeding of the Commission or it is proceeding before the Commission, neither of the proceedings shall be invalidated on account of a vacancy. Because, my Lord, what is the idea behind it? The idea behind it, my Lord, I tell myself is, idea is Commission must not be rendered dysfunctional. There is a public interest. People may come, the people may go. There may be hearing, there may not be hearing. Before the hearing, there may be vacancy. In course of hearing, the vacancy may come. Commission must not be rendered dysfunctional to ensure that. Section 93 takes that care. It's a substantive provision of law.
Not in valid proceedings.
Yes. So whether proceedings of the Commission or proceedings before the Commission, it is applicable to both. Then, my Lord, I further submit that even otherwise, Regulation 2006 cannot travel beyond the scope of the power under which it is made. It deals with the specific subjects. It ought to have been confined to those very subjects and should be read and understood accordingly. Neither more nor less. Then, my Lord, I have already made it clear that there is a distinction between proceedings of the Commission under Section 92(1), which is very clear, my Lord, from the subsequent proviso, namely subsection 2, subsection 3. Both subsection 2, let us read, my Lord, subsection 2 and 3 for a moment. Again, 92(1), I'll start with that, then I'll come to subsection 2 and 3. The appropriate Commission shall meet at the head office or any other place at such time as the chairperson may direct, and shall observe such rules of procedure in regard to transaction of business at its meeting, including the quorum at its meeting, as it may specify. Subsection 2. The chairperson, or if he is unable to attend a meeting of the appropriate Commission, any other member nominated by the chairperson in this behalf, and in the absence of such nomination, or where there is no chairperson, any member chosen by the members present from amongst themselves shall preside at the meeting. So again and again, my Lord, we are referring to meeting only of the Commission. 3. All questions which come up before any meeting of the appropriate Commission shall be decided by the majority of votes of the members present and voting, and in the event of an equality of votes, the chairperson, or in his absence, the person presiding, shall have a second or casting vote. 4. Save where otherwise provided in subsection 3, every member shall have one vote. Voting, my Lord, naturally in the meeting the votes take place. There are dissenting opinions given in the meeting. Such a thing doesn't happen when there is a proceeding before the Commission. You don't vote. 5. All orders and decisions of the appropriate Commission shall be authenticated by its secretary or any other officer of the Commission duly authorized by the chairperson in this behalf. So, but all that, my Lord, comes with the rider of Section 93. Come what may, if such a vacancy comes, it will not be invalidated.
Yes.
Then, my lord, accordingly I submit that proceedings of the commission, the difference between the two is, there are twofold distinction between the proceedings of the commission and proceeding before the commission. The proceedings of the commission doesn't have trappings of judicial proceeding, unlike proceedings before the commission. Nor commission will be a civil court while holding section 92 proceeding. It won't be a civil court in any manner while holding section 92 proceeding. And further, proceedings of the commission under section 92 subsection 1 are in respect of transaction of business in its meetings. That is clear, I have clarified. Now, my lord, just one proposition I will advance here because this is the right point, otherwise again I will digress. In section 92, additionally, just to further, my lord, strengthen my argument, in section 93 subsection 1, we see a particular expression. That is proceedings of the commission. It is a heading of the commission. Under the heading, there are various provisions. The provisions, subsections may not make it very clear. Transaction, proceedings of the commission are in respect of the meetings. But even otherwise, my lord, I'll just refer to one particular judgment. Because one may argue, look, heading is very clear. And accordingly, the contents in the section 92 should be understood in conformity with the heading itself. For that, my lord, I will give a clarification. That is 2004 4 SEC. Page 766.
Just come again, please.
Justice Lahoti's judgment, my lord. 2004, 4 SEC.
Yes.
Page 766. Relevant page 775. Para 14, 1-4. I'll just read, my lord, the relevant portion, para 14 itself. 775.
Mr. Books have been given. Mr. Books, not to us. I don't have copy, my lord, of this boy, nor they have given me the in copy in advance. At least I should know how do I meet their argument.
Likewise, my lord, the judgments my esteemed colleague may cite. I don't have the copies also.
I have already referred to in my encounter.
We never asked for these things.
I need copy because you are citing and I have to meet that. That is the basic.
So paragraph 14, my lord, I read. Paragraph 14. The view is now settled that the headings or titles prefixed to sections or group of sections can be referred to in construing an act of the legislature. But conflicting opinions have been expressed on the question as to what weight should be attached to the headings or titles. According to one view, the headings might be treated as preambles to the provisions following them so as to be regarded as giving the key to opening the mind of the draftsman of the clauses arranged thereunder. According to the other view, resort to heading can only be taken when the enacting words are ambiguous. They cannot control the meaning of plain words, but they may explain ambiguities. See Principles of Statutory Interpretation, Justice G.P. Singh, 9th edition. Now from thereafter, Justice Lahoti says, in our opinion, it is permissible to assign the heading or title of a section a limited role to play in the construction of statutes. They may be taken as very broad and general indicators of the nature of the subject matter dealt with thereunder. The heading or title may also be taken as a condensed name assigned to indicate collectively the characteristics of the subject matter dealt with by the enactment underneath, though the name would always be brief, having its own limitations. In case of conflict between the plain language of the provision and the meaning of the heading or title, the heading or title would not control the meaning, which is clear and plainly discernible from the language of the provision thereunder. Now, my lord, on this, my only submission is, over here I don't see any ambiguities whatsoever. My submission is, the heading and the contents of section 92 by way of subsections, they align completely, because the meetings of the commission and the proceedings of the commission, they align. They are in sync with each other. The proceedings of the commissions are always in respect of the meetings of the commission, during which there is transaction of business. That is the limit and the scope of section 92. Then, my lord, similarly in connection with this, my further submission is, there is yet another distinctive feature between the proceedings of the commission and proceeding before the commission. Proceedings of the commission refers to comprehensive range of actions and functions. So far as proceedings of the commission are concerned, it refers to comprehensive range of actions and functions and encompasses all the actions taken by the commission, including administrative functions, rule making power, etc. But so far as, my lord, proceedings before the commission is concerned, it is to be understood in a narrower context. It refers to cases or matters under consideration. There is consideration, there is adjudication, there is hearing, and there is a disposal. That is proceeding before the commission. Now, my lord, I come to the Regulation 8. Now I'll make it clear, because the commission in its impugned order emphasized upon the contents of Regulation 8 of the regulation. My next leg of argument. My lord, will find incidentally at page 38 of the paper book in definition clause, that is 2C, the meeting has also been defined. Meeting means meeting of the commission convened for the purpose of considering a matter. Naturally, because in every meeting, my lord considers a matter only. But the question is, it is in-house proceeding to deal with various aspects of administration. Now, Regulation 8. The page 39 of the paper.
Proceedings of the commission.
Yes. Proceedings of the commission. Regulation. Now, interestingly, my lord, first of all, the heading, proceeding of the commission. Then I come. Sub-regulation 1. All hearings, examination, inquiries or consultations held or conducted in a meeting. So, my lord, it deals with all that. Be it hearing, be it examination, be it inquiries. There may be departmental proceeding also, my lord. That is why hearing, examination, inquiries or consultations held or conducted in a meeting shall be deemed to be the proceeding of the commission. The meeting can't be, my lord, in a commission. Meeting of the commission cannot be in connection with the judicial proceedings or quasi-judicial proceeding. 2. A matter shall be heard or considered by the commission in a meeting. 3. Commission, while hearing or considering a matter, may, if it considers it necessary to do so, co-opt an officer or any person possessing knowledge or adequate experience in a particular field to be present and take part in the meeting, but such officer or person shall not have the right to vote. I ask myself, my lord, if there is a hearing on determination of tariff, whether commission can co-opt a person like that, and whether that person, the question would be whether that man has a right to vote or no right to vote. Such a thing is not possible, my lord, when hearing takes place. Of the kind of hearing, my lord, we are talking about in the present case. That is, so this is what, my lord, the meaning of Regulation 8 is all about. It is all meetings of the commission. Now, my lord, sub-regulation 4 of Regulation 8 has nothing to do with the 1, 2 and 3. It is absolutely pari-materia with section 95. That is a difficulty. It is for them how to make regulation. But the regulation itself, my lord, has not been made properly. It is misplaced here. Because dicto, my lord, it is section 95. All proceedings before the commission shall be deemed to be judicial proceeding. That is a different thing altogether. That is section 95. Substantive provision. We have no quarrel with that. I am concerned with sub-regulation 1, sub-regulation 2, sub-regulation 3 of Regulation 8. So therefore, my lord, so far as Regulation 8 is concerned, my submission is Regulation 8, sub-regulation 1, 2 and 3 are in relation to section 92 of the Act. Only, nothing more, nothing less. So far as sub-regulation 4 of Regulation 8 is concerned, it is in sync with section 95. That is all. it does not help the Commission at all. In arriving at a conclusion, it did in the present case. Then comes, my lord, Regulation 12. Regulation 12 may also kindly be seen. Regulation 12, my lord, talks of initiation of proceedings. Sub-Regulation 1. Proceedings shall be initiated on a petition filed by an affected person before the Commission, provided that the Commission may suo motu initiate a proceeding on a matter that may come to its notice if it is satisfied that it is necessary to do so in public interest. My lord, I am clarifying. So far as Regulation 12 is concerned, my submission would be that Regulation 12 covers the proceedings under Section 94-95 of the Act. Regulation 12. It is true, this regulation, my lord, widens its scope and goes far beyond the subject under which it is made. I have no quarrel with that, you do it. But you will have to be read accordingly. So, sub-regulation 1 again deals with the proceedings under section 94 and 95. Sub-regulation 2. If a petition is admitted, notices shall be issued for filing of replies by the parties concerned as the Commission may direct, provided that before admission of a petition, the Commission may, if it considers it necessary, direct that the facts of the subject matter of the petition be examined or inquired into by an officer or any other person it deems fit. 3. The Commission may, if it considers necessary, order the publication of petition or reply inviting comments from members of the public on the substantial issues involved. My lord, since I have already submitted, so far as Regulation 12 is concerned, it covers the subjects of proceedings under section 94 and 95, not 92. Now, my lord, I turn to Regulation 18. This is very, very significant. This I will have to clarify. Because this is what, my lord, the Commission in its impugned order emphasized a lot. Sub-Regulation 18. Yes. Page 43. Yes. Decisions and orders of the Commission. Regulation 18. Sub-Regulation 1. On completion of a hearing or consideration of a matter, the Commission shall give its decision with reasons therefore, and shall pass orders, including orders with regard to costs. 2. The Commission may also pass interim orders as may be necessary from time to time. 3. All orders of the Commission shall be signed and dated by the chairperson and members hearing the matter, and shall not be altered except to correct any apparent error. 4. In any proceeding, the decision taken by the majority shall be the decision of the Commission, and in case of dissent, the dissenting member shall give his views separately. Now, my lord, my submissions are as under. First, since the regulation is made under section 92 and 181 2ZL, it should be read to regulate a transaction of business related to those substantial provisions of the Act under which the regulation is made. If my lord finds that particular provision of the regulation travels beyond that very subject, that has to be ignored. That's my first submission, subject to my lord's consideration. Then secondly, functions of the State Commission under section 86. Lordship may see kindly 86 also. And 181. 86, my lord, I think determination of tariff. Functions of history, sorry, yes. 86. Functions of State Commission, beginning from determination of tariff to below various facets, primarily determination of tariff, regulate electricity purchase, etc. So, functions of the State Commission under section 86 and 181 subsection 1 of the Act are not governed by the regulation. Because regulation is not made thereunder. It's a generality of the provision, all right. But when specifically you choose to exercise power, I'll put it this way, when you refer to Taylor versus Taylor in a different avatar, you are also governed by the same principle. Then thirdly, my lord, Regulation 18, Sub-Regulation 3, because therein lies a catch. Sub-Regulation 3 says, all orders of the Commission shall be signed and dated by the chairperson and members hearing the matter and shall not be altered except to correct any apparent error. Regulation 18, Sub-Regulation 3 has to be read in harmony with Section 93 so as not to negate or defeat the objective of Section 93. Because 93, my lord, is a substantive provision. The regulation, my lord, having been made in exercise of delegated power, cannot go beyond the very scope of a substantive provision. Section 93, my lord, is very wide in its sweep, very wide of the proceedings and before the commission, both I have said. So, my lord, 18.3 is subject to Section 93. It can't negate and defeat the very scheme and the very objective of Section 93. If it is argued that all orders of the Commission, those who hear, they must sign it, if to strengthen this argument, if reliance is again placed that one who decides must, one who hears must decide, then the argument is very simple. Here is a case that the person who heard, he decided. It is a different matter, though two heard the matter, but one passed the order. But the principle was not violated. So the Gullapalli principle, my lord, has no application whatsoever. That I submitted is entirely, my lord, a different thing altogether. The Secretary of Transport did not pass the order, Chief Minister passed the order in Gullapalli case. Same is the case with the Rashid Zaved. So that principle is not violated. Now, my lord, I'll come to the reliance by Commission on Damodar Valley and the Jindal. They place a reliance.
Yes.
My lord, yes, I admit that the principle of law laid down and explained both in Damodar Valley as well as in Jindal case supports the case of the public utilities and the Commission in the impugned order. It supports their case, the conclusion they have arrived at. I admit and I concede that. But the question is, my lord, even the Commission, number one, Commission is not the appellate tribunal. So far as appellate tribunals are concerned, my lord, they are bound by judicial discipline. In a certain case, my lord, they chose not to do so. Because the larger bench direction under Section 121 was binding on all the smaller benches of the appellate tribunal. Appellate tribunal violated that very particular judicial discipline. They acted in gross judicial discipline. But, my lord, the Commission was bound by that. Commission ought to have followed the general direction of the larger bench of the Commission, ignoring, my lord, the orders which were in conflict with that direction of 121. In any case, my lord is not bound by anything. It is open for my lord to decide the law. There are orders of the appellate tribunal from both the sides, and my lord will decide which position of law is correct.
Yes.
In a certiorari jurisdiction. Then, my lord, straight away I will turn to the direction of the three-member bench of the APTEL, which is very vital. Lordship, may kindly have the copies. There are, I hope paragraphs are similar. Kindly give it to my colleague also. Please. You have it, I'll read from here. Now, my lord, before I read the relevant portions of the full bench, three-member bench direction of the appellate tribunal, my lord, I'll just point out the discussion on forum and the requirement of quorum begins from paragraph 5. Before that, there is no discussion on quorum. Paragraph 5. Just I'll my lord, we have gone through the forum. Is it?
Para?
Yes, yes. Paragraph are similar. Para 5. The discussion starts. And my lord, it goes on and continues till paragraph 18. From para 5 to accordingly ordered. So, we will leave that accordingly ordered. So, 5 to 17 are relevant. There is a discussion. From paragraph 5 to paragraph 17, total 12 paragraphs, the commission in its wisdom selectively chose 3 paragraphs, 11, 12 and 17, which I read earlier. Very selectively they took these 3 paragraphs. I will read from paragraph 5 itself. Because they wanted to reach a particular conclusion. That is why it was inconvenient for them to refer to everything from paragraph 5 onwards. They selectively refer to 3 paragraphs. No, sorry. Yes. 11, 12 and 17. Now, my lord, para 5, I starts. We have gone through the Forum of Regulators report dated 16/9/2013 with regard to the issue of quorum. In this report, they have reported as follows. Now, my lord, the 3 states have been discussed because there were reports from 3 states that the commission was dysfunctional in those 3 states because of the problem of quorum. That is Andhra Pradesh, Jharkhand and Tamil Nadu. A. The state of Andhra Pradesh, Jharkhand and Tamil Nadu are non-functional due to lack of quorum. B. As regards the Andhra Pradesh State Commission, the State Commission is reported that the AP Reforms Act provides for a quorum of 2 members. C. In regard to Jharkhand State Commission, clause 10 of the Conduct of Business Regulations provides for a quorum of 2 members. The State Commission has reported that the position of chairperson and member finance are lying vacant since 16/12/2012. D. As regards the Tamil Nadu Commission, it is noticed that clause 12 of the Conduct of Business Regulations provides for a quorum of 2 members, but the State Commission has reported that the post of the chairman as well as the member were vacant. On the basis of this report, we deem it appropriate to give the following directions to these commissions. These are general directions, my lord, which had gone to the commissions of 3 states. A. It is settled a law that the regulations with regard to quorum cannot be framed as against the substantive sections of the Electricity Act 2003. The functions of the State Commission under Section 86, 86 Lordship has seen, are the series of powers which are given to a State Commission. 86 and 181 of the Act 2003 would, in terms of the Conduct of Business Regulations, have to be discharged through the proceedings for which no quorum have been specified under the Act. My lord, because even the regulation, the power to make regulation under 181, whether we require a quorum for that? The answer is no. That, of course, my lord, that would be transaction of business in the meeting of the commission. Right. Say, for example, the required members are not there. Does it mean regulation cannot be framed? Regulation can still be framed under 181. So, it has to be discharged through the proceedings for which no quorum have been specified under the Act. B. Of course, there were regulations framed by some other commissions relating to the quorum. Those regulations also would refer to the quorum only for the meeting of the commission. Very clearly it says. Those regulations also would refer to the quorum only for the meeting of the commission and not for the proceedings before the commission. So, before the commission, not of the commission. C. These regulations provide that the commission may hold such proceedings as deemed considered appropriate in discharge of its functions under the applicable legal framework. It also provides that all other matters may be decided by the commission administratively through the meeting of the chairman, member and secretary or other officers of the commission. Para 7. Thus it is clear the conduct of the business regulations framed by the commission specifically differentiate between the proceedings before the commission and the meetings of the commission. It rather used the expression meetings of the commission. We may very well say proceedings of the commission. It is one and the same thing. In this context, it is to be pointed out that this tribunal has already rendered judgments while interpreting Section 93 of the Electricity Act 2003 that any decision taken by the Commission should not be invalidated by a mere fact that there is some vacancy either of the chairman or member. 9. In view of the above decision, we are to direct all the commissions to conduct the proceedings irrespective of the quorum. Irrespective of the quorum, since the proceedings before the commission could be conducted even by a single member. Since the proceedings before the commission could be conducted even by a single member. Of course, Section 82, subsection 4 of the Act 2003 provides that the State Commission shall consist of not more than 3 members, including chairperson. That is not constitution of the State Commission. However, Section 93 of the Act of 2003 provides that no act or proceedings of the appropriate commission shall be questioned or shall be invalidated merely on the ground of any vacancy or defect in the constitution of the appropriate commission. My Lord, pausing here, I submit Section 82, subsection 4, my Lord, Section 82 itself, my Lord, provides for the constitution of the commission. There is no quarrel with that. Commission may be constituted as per the mandate of Section 82, but Section 93 deals with the situation when the vacancy, there is a vacancy, my Lord, in the commission itself. So Section 82, my Lord, Section 82 does not give quorum. It only provides for the constitution. There is a distinction between the two. Then comes para 11. In our view, since the quorum depends upon the number of members in the House, even single member of the commission, including the chairperson of such a commission, can conduct the proceedings of the appropriate commission. My Lord, there may be two situations. I'm sorry, I'll complete it. There may be two situations. Number one, there is a vacancy. Only single member is there. There can be a proceeding before him. Number two, a situation where 2 members are there, proceeding begins before them. In course of the proceeding, there is a vacancy, one retires. My submission is proceeding can still continue. A third situation may be, yes, and my Lord, hearing initiated, concluded, before passing of the order, 1 member retires. Even then, my Lord, lone member present can issue the order. 12. Therefore, we direct that all the commissions concerned, irrespective of the regulations, with regard to the quorum for a meeting, that commission, even with a single member, despite that there are vacancies of other members or chairperson, can continue to hold the proceedings and pass the orders in accordance with the law. Before parting with this order, we have to record one more aspect with a great anguish with regard to repeated instances of institutional vacuum being created due to lack of diligence by the respective appointing authorities in filling up the vacancies. The important statutory role has been assigned by the Parliament to the State Commission, which includes safeguarding the consumer's interest and sector viability. In the context of the above concern, in view of the delays in appointing all members of the Commission or filling up all the posts of the Commission in the commissions, we are afraid that the institutional vacuum would cause delay the vital decisions to be taken by the Commission, which will result in the defeat of the object of the Act of 2003. Hence, we are constrained to advise the Ministry of Power to take note of this issue and take suitable steps, as repeated failure to implement an important reform legislation will erode the pace of the reforms in the implementation of the provisions of the Act. Therefore, we direct the Secretary, Forum of Regulators, to forward a copy of this order to the Secretary, Ministry of Power, Government of India, for emergent suitable action with the appointing authorities of the respective states for taking timely action for appointment of the members, chairperson of the state commissions by filling up the vacancies without any delay. We also deem it fit, para 17, we also deem it fit to direct the commissions to amend the regulations, if any, to the effect that if there is only 1 member of the commission available, the quorum of the proceedings of the commission also shall be 1, accordingly ordered. Now, my Lord, though, my Lord, specifically, the 3-member bench commission did not refer to any section under which it was exercising its powers. I can take my Lord to section 121 of the Act. That is the power. Though power may not be mentioned, mere non-mentioning of the power by itself, my Lord, would not create any difficulty if the power can be located. Section 121. Power of Appellate Tribunal.
Yes.
The Appellate Tribunal may, after hearing the appropriate commission or other interested party, if any, from time to time, issue such orders, instructions or directions as it may deem fit to any appropriate commission for the performance of its statutory functions under this Act. So it's a general power, very wide power, vested in the appellate tribunal to issue directions from time to time to ensure that the appropriate commissions perform their statutory functions under the Act. Because, my lord, the power which is vested in the State Commission is a very vital power. It has to determine the tariff. It has to listen to the consumers as well as to the producers and the distributors of electricity. If the commission is, my lord, non-functional because of the lack of quorum, the Act provides a remedy. So, my lord, my submission is that the direction of the three-member bench of the APTEL, number one, was binding on the commission. Commission could not have deviated from this direction of the three-member bench of the commission. Number one. Since it was binding, so commission was helpless. I would submit like this. Secondly, my lord, in view of the direction of the three-member bench, the two judgments of the appellate tribunal, taking a view which commission took in the present case, they have absolutely no effect. In any case, my lord, be it the direction of the commission or by the three-member or by other orders of the appellate tribunal, my lord is not bound by anything. My lord has seen this very conflict here. Lordship will take a view, wider view, Lordship will look into the law, and my lord will lay down the law as to what is the scheme and the object of the provisions, whether there is a requirement of quorum or not. I will only refer to, my lord, the two other orders of the commission, where the two other orders of the appellate tribunal, where they have taken an approach which is similar to the direction of the three-member bench. I will just give those two citations. These are, my lord, number one is, that is Faridabad Industries case. This is 2011 SEC, just a minute. Yes, 2011 SEC Online, APTEL 127. I will just give the paragraph numbers, I will not read below because they have taken this approach, which is favorable to us, which is in line with the paragraph 4.6, yes. 11.3, and 11.4. Then, my lord, there is yet another order of the appellate tribunal that is reported in, that is, yes, that is, yes, that is reported in 2013 SEC Online APTEL 138. The relevant paragraphs are para 38, 39, 42 and 43. Of course, my lord, there are judgment orders to the contrary, Damodar Valley and Jindal case, which commission has referred. I am referring to this just to show there is a conflict of opinion and there is a gross judicial indiscipline so far as appellate tribunals are concerned. They are not following even the direction of the larger bench of the appellate tribunal. Now, my lord, additionally, I have few other submissions to make. My lord, that is in connection with section 82 subsection 4 of the Act, which deals with constitution of the commission. There also, my lord, there is one clarification I would like to give. '82 Constitution of State Commission, subsection 4. The State Commission shall consist of not more than 3 members, including the chairperson. My lord will here take note of the fact it's an upper limit. Commission shall consist of not more than 3 members. It will not have more than 3 members. Yes. So, meaning thereby it has only one meaning, maximum 3 members. It doesn't talk about the vacancy, it doesn't talk about the lower limit. Lower limit certainly can't be 0, it has to be 1. So between 1 to 3 it can be anything. Constitution, yes, 3. That is the upper limit. There is no provision in the law which says that 3 will have to be there at all point of time. That, if that is the interpretation given, my lord, the commissions will become dysfunctional. Section 82 subsection 4 is silent on quorum. it cannot be misunderstood with quorum. That, my lord, has been clarified by the 3-member bench direction. It can't be confused with the quorum. It's a constitution, an upper limit it gives. And Lordship may take note of the fact that so far as section 93 is concerned, the Commission in the impugned order only quotes section 93. It doesn't explain the consequences of contents of section 93.
That's seen here.
So the impugned order, my lord, my submission is violates the clear mandate of section 93. Regulation 10 is also there. I'll just point out interestingly. Regulation 10. I hope I didn't. I think I missed it earlier. Yeah, quorum. So yes, regulation 10.
You already spoke.
I think yes. No. I think possibly my lord is right. I refer to it, and my submission was just a brief recap. My submission was that requirement of quorum in regulation 10. This very requirement by itself, my lord, its scope is limited to section 92. Where the Commission has also 1 member or more, the quorum of any meeting shall be 2, including the chairperson. At the most, my lord, regulation 10 can be associated with section 92. But again, the caveat is section 93 is always there to take care of any contingency. It's very wide in its sweep, open-ended expression, whether proceedings of the Commission or proceedings before the Commission. 93 takes care.
Yes.
So, my lord, I sum up and I make the following submissions. I'll just jot down the important points. My first submission is quorum has not been provided for under the Act for proceedings before the Commission. Under section 94, 95 and 86. 86 with regard to powers of State Commission. No quorum has been provided for under the Act.
Yes.
Secondly, quorum has been provided for transaction of business in a meetings as mandated by section 92. But again, that comes with section 93 baggage, which is why did it sweep. Then thirdly, quorum is spoken of.
Yes.
Quorum is spoken of under section 92 and regulation 10. Regulation 10 also talks about quorum. Quorum because quorum was there, my lord, in 2 places only. That is section 92 and regulation 10. Specifically, quorum is spoken of under section 92 and regulation 10 is in respect of meeting of the Commission for transaction of business.
Yes.
And such meetings have to be conducted in terms of regulation 9. Regulation 9 is also there, Lordship may have a look.
Yes. Conduct of meetings.
Yes. Conduct of meetings. Lordship has seen it already. Then, my lord, my fourth submission is proceedings of the Commission under regulation 8, sub-regulation 1, 2 and 3 are in respect of the meeting of the Commission only. Then, proceedings under regulation 8, sub-regulation 4 of the regulation is in respect of the proceedings within the meaning of section 94 and 95 and for discharging functions under section 86. 86 State Commission's functions.
Yeah.
Then requirement of signing of the orders by all of those, that is chairperson plus members who hear the matter under regulation 18 sub-regulation 3 has to be read in harmony with section 93. This requirement that all those who hear must sign, that has to be read in harmony with section 93.
Yeah.
Then, my lord, sixthly, the Commission is bound by the direction of APTEL dated 2/12/2013 in OP number 1 of 2011. It ought to have ignored the contrary orders of the appellate tribunals.
Yes.
Then, my lord, this is already there. Lordship has taken note of this submission. That is, regulation having been made under section 181(2)(ZL and section 92 of the Act must be limited to the scope of the subject under which it is made. To the extent it transgresses other areas, it must be read down.
Yes.
Because ultimately the purpose of the regulation for which it is made, it is to fulfill the very purpose of the subject. Neither more nor less. But in any case, my lord, even otherwise we read the regulation, my submission is 93 cannot be done away with. Very wide in its sweep. Then regulation cannot be read and understood in a manner to negate and defeat the substantive provisions of the legislation.
Yes.
It must serve the object of the legislation and not defeat it.
Yes.
Then, in any case, my lord, my submission is already, the lordship has taken note of that. This doctrine that one who hears must decide has not been violated. Gudla, Paldi and Rashid, those cases have no application whatsoever. Then, my lord, on the basis of these submissions, my lord, my only appeal before my lord is that here is a case where it cannot be held that the impugned order of the commission dated 6th of June was without jurisdiction. It was not without jurisdiction. It was never a nullity. If it was not a nullity and not without a jurisdiction, the question of recall does not even arise. If that be the case, the consequences follow. The subsequent order of the commission laying down the different tariff rate has no legs to stand. It has to go. But in any case, my lord, I'll give a few judgments on this point, that when power of recall can be exercised, the scope of judicial review. Lordship, one judgment would suffice the purpose, because my Lord Justice Chandrachud has referred to a series of case laws. Yes. 2024, volume 6 SCC, page 767. That is Greater Noida versus Prabhujit Singh Soni. The paragraphs are wherein different judgments have been referred to with approval. Para 46, para 47, para 49 and para 50. Para 50 only I will read. My lord will find para 50 at page 795. I will come to the guiding principles which are at the bottom of para 50. Placitum F. It starts from the end of placitum E. The relevant portion is at placitum F.
How of such exercise sparingly?
My lord, that is it. The order is A, B, C. Yes. A, the order is without jurisdiction. B, the party aggrieved with the order is not served with notice. That is a violation of the principles of natural justice. The party agreed with the order is not served with notice of the proceedings in which the order under recall has been passed. And C, the order has been obtained by misrepresentation of facts or by playing fraud upon the court, tribunal, resulting in gross failure of justice. My lord, here is a case where the order is not without jurisdiction. So the power of recall could not have been exercised. And my lord, so far as, my lord, the jurisdiction of this honorable court under Article 226 is concerned, subject to nature of submissions made by if my London colleague makes in this case, I will, my lord, give a reply. Because we are in a certiorari jurisdiction, and my lord, my argument would be that here is a fit case where my lord should exercise the certiorari jurisdiction. The scope of certiorari, my lord,
that take longer arguments than Mr. Tiwari.
If subject to, my lord, if these submissions are made, that there is some other remedy.
If you want to go to that area, then it's a different realm.
My lord, I can't presume. So, my lord, I would not argue on this aspect. My lord, lastly, only one thing.
Yes.
Is it only one, my lord? It is on the question of retrospectivity. Because my lord has just, lordship may see one very interesting aspect of this case. My lord will turn to page 31 of the paper book. That is the order of financial year 23-24. Order dated 11th of April 23, tariff order.
Yes.
At page 31.
Yes.
My lord, the last line, page 31.
This order will be effective from
1st April 23 and shall remain in force till 31st March 2024. Lordship will take note of the letter date and shall remain in force till 31st March 2024 or till the next tariff order of the Commission. Meaning thereby, if the next tariff order doesn't come on time, this order continues. Because there can't be, my lord, an intervening period in the matter of tariff. So, or till the next tariff order of Commission. Then, my lord, we turn to the page 37. The next tariff order. Page 37.
Well.
Yes. This is the tariff order, the 6th June, which was held illegal by the subsequent order of Commission, which was recalled. This order shall be effective from 1st June 24 and shall remain in force till 31st March 2025 or till the next tariff order of the Commission. There is no difficulty about this one. Because on the order is dated 6th June, so for 1st June they applied it. Not in conflict with the previous order, where it was said, shall remain in force till 31st March 24 or till the next tariff order. So, my lord, 1st June 24. Now, what happens, my lord, with the impugned order 24-10-24, page 142?
Yes, Mr. Tiwari will continue after lunch.
Only this. Only
You
this.
conclude assumptions.
No, only this, just show. This order shall come into effect from 1st April 24. That is retrospectivity. 142. It's not very.
1 second.
Lordship has seen 142.
It's very what do you call explicit.
That's it. Retrospectivity. 1st April.
Yes. Yes.
How they have done it?
Orders.
Lordship, just give this. Actually, it is on a different footing a little bit. It can be distinguished. But anyway, retrospectivity is in a matter of tariff.
The rest of the matters are after 2 days.
Very
Any
well.
order matters, Mr. Jindal.
Item number 35, my lord.
Next week.
35 is what? It's a hearing matter.
It's for hearing, my lord.
Hearing.
This matter can be taken up next week.
Yes.
I am, Milords, hearing for the commission, but Milords, I am instructed to appear in item 41 where Mr. Paul is leading them, Milords, I believe.
Yes.
So would your lordships be pleased to hear us today, or would your lordships would want to hear Mr. Paul and then...
See, the thing is that, Mr. Venkatesh, we're hearing the entire matter on the point of law has been raised. And
Yes.
since the comment is a basic conversation, that will also, he's made a prayer that whatever is the outcome or whatever the hearing proceed, but then he just makes supplemental submissions later on.
Yes,
so that's
and then we listen to your lordships, postman.
Then they will hear you also, like, in conjunction all the other matters, yes.
Yes.
Yes. 35 after 1 week.
Lordship, 35 next week.
1 week. After 1 week. 1 week.
My Lord, just on retrospectivity, the Supreme Court judgment in Mindani case, paragraph 30. Please. Para 30. It is a general principle Supreme Court has explained in para 30.
Just be Sinha.
That's all.
May it please your Lordship. If I have understood my friend correctly, my Lord, is akin to saying that the matter can be heard by both.
He's given a very interesting twist to the whole thing.
Yes, my Lord.
With regard to off and before.
I will deal.
Whether the Regulatory Commission is, in which capacity had it taken up the matter?
Yes, my Lord. It's a red herring. I will say it is a red herring, my Lord.
Red herring?
Red herring. Why it is red herring, my Lord? That if Lordship kindly visualize a situation where, my Lord.
One second. Yes. Yes.
It's a red herring. Why I say so, my Lord? That it is not in dispute.
Yes.
It is not in dispute that matter was heard by two persons, chairperson and member.
Right.
And decision has come from one member.
Yes.
The argument is, my Lord, that the member was competent, there was no requirement of quorum, and since he has heard it along with the other member, he can pass the order, tariff order. It's like, my Lord, two judges have heard the matter and one judge has passed the order. It's like a writ which can be heard by division bench and writ can be heard by single judge also, my Lord. When matter is heard by division bench and one member has passed the order saying that yes, he could have heard the matter singly and therefore he is competent to pass the order. This is not hearing, my Lord. Hearing, they heard it together. And the order has to come together. If they would not have heard together,
yes,
they could not have, this one member could not have passed the order. Kindly envisage a situation where the two members are there. One member does not sign the order, my Lord. The other member passed the order. Would that amount to tariff order under the Electricity Act, my Lord? Here in this case, person has retired. So if the contention or the submission of the petitioner is accepted, my Lord, it would amount to saying that even if both the members are competent, hearing has taken place together, one member can pass the order. And that order is binding, valid and in accordance with law. Quorum, regulations, I will read three provisions to say that it is these are for administration of the commission, for the commission, and one I will say that it is not applicable. But I request your Lordship need not venture in that area for one reason. Why? Because in that area, my Lord, your Lordship, both sides have cited the Aptel orders, 2013, Jindal and all. All these matters can be and can be argued under section 111 before the Aptel. This view has already been because if they cross this threshold, that the writ code can go into this matter, then only your Lordship's occasion would arise for your Lordship to go into the second issue. I did not hear anything from my friend on that point, though I have extensively taken objection in my counter. Maintainability. But be as it may, my Lord, let's first deal with the issue of, my Lord, maintainability issue, because that maintainability issue, my Lord, is no longer res integra, especially for this court. After this court has taken a view in this matter.
Yes.
After this court has taken, this honorable court has taken view in this matter and relegated the parties time and again to the alternative forum, my Lord. One order is of your Lordship and the other order is of the division bench of this honorable court, which I assailed before the honorable Supreme Court and lost it, that I have to go before the appellate forum. The question which arises in my humble submission is that whether all these issues and orders can be tested by the APTEL or not, my lord. If those orders can be tested by APTEL,
Yes. Then
matter should ordinarily go to the APTEL and APTEL alone. That is my submission, my lord. Your lordship, kindly see my objections in this in regard to first item, my lord, and the other item 23 only, my lord, my friend's item, my Pioneer Carbide Private Limited, because that will be convenient now that this is the matter. And before I take your lordship to these items, my lord, kindly also appreciate one point, that in two matters there is a challenge to the tariff order, the subsequent tariff order.
The others is only like
the electricity bill they have challenged. So Sham Century, that is the item number, Sham Century, item 13 of 2020, item 13 of 2025, writ petition 13 of 2025, my lord. And in writ petition 9 of 2025, my lord, challenge is
tariff
to the tariff or subsequent tariff order.
You see number 25.
Writ petition number 13 of 25 and writ petition number 9 of 25, my lord. There is in other writ petition only
to the bill.
To the bill, and that too not the current bill, the areas which have been directed to be paid in terms of the tariff order, my lord. To be fair to the in BIA, my lord, the item, the other one, my lord, the order is challenged to the recall order, not to the subsequent order. Give me the call.
BIA is a challenge to the recall order.
A recall order.
Not to the order passed in August.
And not in the October.
23rd is recall order is 23rd October. August.
No, that the order is 5th June and 6th June.
No, recall order is 23rd August.
23rd August, and October order is, that is the tariff order is not under challenge.
Okay. The BIA tariff order under challenge.
And not under challenge.
We have challenged.
Yes, I am saying.
No, really have challenge. No, I'm talking.
Because only for the putting the record straight, my lord. Only for putting the record straight, my lord. The challenge is in. Challenge is confined to.
So in Sham Century, that
Sham Century, my lord, and Pioneer Carbide is.
Pioneer Carbide, this is 9.
Yes,
out there is a challenge to the entire,
Entire. They have challenged, but there is no challenge, my lord, to the regulation. They are asking this court to read down the regulation, my lord. Kindly see the prayer, my lord. What they are asking for is beyond the scope to read down the regulation, my lord. If I have heard correctly, my lord, in submission was also to read down the regulations. So, prayer is 21, my lord, set aside and quash the order of 23rd August passed and 24th October. So, the regulations as existing today, my lord,
they are not under any challenge.
It's not under any challenge. And prayer is to read down the regulation. But I need not venture or go in that area, because my first and foremost challenge is as to the maintainability of writ petition and availability of alternative efficacious remedy, my lord. Because all of us are relying on APTEL order. All of us are relying on APTEL order, my lord. So kindly see, my lord, because if this threshold is crossed, my lord, and we have also taken the ground of perjury also, my lord, because they have not approached the court with clean hands. Kindly see my counter affidavit. There is no submission on that aspect also, my lord. There is no, because they came to this honorable court, my lord.
Yes.
And did not place 2 letters by which they have sought that they wanted to pay, but they are unable to pay because of financial constraint. So per se, my lord, there was no challenge before the authority as such regarding the tariff order. Kindly see page 3, paragraph 7
of the affidavit.
Of my affidavit, my lord. So my first submission is that the petitioner has not approached this honorable court with the clean hands, and therefore the writ remedy, which is an extraordinary remedy, could not have been invoked in paragraph 6 and 7, my lord. It is submitted that petitioner number 1 to have admitted in their letter of 2012-2024 and 24 that they agreed to make the payment of electricity bill towards the terms of order, my lord. Kindly 7, my lord.
Yes.
Petitioner have concealed the fact while later dated 18th January 2025 and 21st January sought extension of due date due to financial constraint. The petitioner have not objected to payment in terms of tariff order and however have sought time for making the payment. And kindly see 18th January letter, my lord.
R1.
R1, my lord, at page 31. We have received the electricity bill for payment today only, whereas the date of payment shown is 24 January because 2025. So this is violation of MECRC Supply Code 2018, according to which 15 days time is to be given and not 6 days. You are requested to kindly revise the date of payment by 31st January 2025 and serve us the revised copy of the bill, my lord. And then, my lord, on next, my lord.
Yes.
Financial be as it may, my lord, the issue which is important, my lord, all is whether there is an alternative efficacious remedy available under the law to the petitioner or not. And for that, my lord, I seek your lordship's kind attention to the Electricity Act, my lord, of section 111. Any person aggrieved by an order made by adjudicating officer under this act,
Yes.
except under section 127, or an order made by appropriate commission under this act, may prefer an appeal to the appellate tribunal for electricity, provided that any person appealing against the order of the adjudicating officer levying any penalty shall file the appeals, deposit such penalty, my lord. Kindly mark this line. Or an order made by appropriate commission under the act may prefer an appeal to the appellate. So an order passed by the appropriate commission under this act. So the order which is under challenge is an order by the commission, my lord. And these two orders are amenable to appeal under section 111 of the appeal to appellate tribunal. They have argued in the learned senior counsel for the petitioner has argued the matter in veiled manner that it is a kind of order without jurisdiction, my lord. And therefore this honorable court has the authority to examine it. We are not at all, and I am not at all for a minute that this honorable court has authority to examine, but my submission is whether the authority under Article 226 can be and should be exercised when there is an express provision of appeal. I should not be understood to say that there is no authority. My submission is that this court
whether writ which will be attracted, whether it can be exercised.
Yes, my lord. My submission.
You cannot bar registration,
this
but
is,
whether in the circumstances
and in view of the alternative remedy,
to show that it's uncalled for.
Yes, my lord.
What remedy they are seeking?
Yes, my lord. I bow down, and this is my precise argument, my lord, that when there is a remedy in law,
yes,
and that remedy is there, they could have gone to the APTEL and they could have exercised the power, and they should have done it. And we are relying on Jindal, we are relying on Damodar, they are relying on the previous order of 2013. All of the APTEL only, on this issue only. So APTEL is in my humble submission, when parties are saying that this kind of issue has been there before the commission, why in this case, in my humble submission, exception should be carved out for hearing the matter before this commission, my lord. And this issue is no longer res integra so far as our own High Court is concerned. My lord, your Lordship has taken a view, give me the compilation. Your Lordship has taken a view in this matter.
You annex the judgment here?
Yeah, I have prepared the compilation, prepared a compilation and regulations and for. Now, your Lordships kindly see, I have annexed the order and judgment also here, but for the convenience, my lord, kindly see from counter itself, my lord, compilation part. On 31st July, page 33 of the counter affidavit, my lord.
Yes.
There was a issue with regard to temporary disconnection, etc. My lord, your Lordship has taken note of the code and paragraph 6 where your Lordship has paragraph 6 at page 37.
Yes.
Coming to the submission of learned counsel on behalf of the respondent, it has firstly been contended the petitioner has alternative remedy available approaching the consumer grievance. It has further been submitted that petitioner has no right to seek waiver, etc. Supply as admittedly that disconnection has been done by petitioner company itself. It has also been argued by the learned so and so. The further even is deciding special tariff and so and so. As noted, the main bone no longer exists for consideration that temporary is requested was sought so and so. Due to now your Lordship kindly mark closure not being agreed to, this court accordingly due to existence of alternative remedy. Paragraph 7, third line. Due to existence of alternative remedy.
Yes.
This code accordingly, alternative as provided under regulation 4 so and so, desists from entertaining instant writ petition. So your Lordship has maintained that when there is an alternative remedy, parties should approach the remedy provided under the Act, under the law, my lord. This view your Lordship has taken in slightly different fact situation, but your Lordship has taken a view which is consistent with the law laid down by the Honorable Supreme Court and even by this Honorable Court, my lord. The next judgment, my lord, on the alternative remedy, my lord, is part of my compilation, my lord.
This is regarding what?
Alternative remedy in regarding, my lord, tariff. We came here, my lord, in respect of a special tariff policy. If your Lordship would recall that special tariff policy and page 24 of the judgment compilation, your Lordship. Yes, my lord. The judgment and order of the division bench of this Honorable Court, my lord. The writ is directed against an order dated December 6, 2022, passed by Meghalaya State Luxury Regulatory Commission at an interim stage of the proceeding issued before it by private respondent therein. There is no dispute that the order impugned is amenable to an appeal under Section 11 of the Electricity Act 2003. However, petitioner power company submits that alternative is neither effective nor appropriate. Present authorization of the primary payer of the petitioner before state government is contrary to finding recorded by this court. I said that this finding is ordinarily when an efficacious, my paragraph 4 I am relying on, my lord. When an efficacious alternative remedy is available, the writ court exercises a degree of self-restraint before entertaining the petition under 226 of the Constitution filed without availing of regular statutory remedy. Exceptional situation in which alternative remedy is disregarded and the writ petition received may when the order is found to be in breach of principle of natural justice and wholly without jurisdiction or absurd to the meanest mind. three parameters, my lord. Principles of natural justice, everybody was heard before the commission, my lord.
Wholly without jurisdiction.
Wholly without jurisdiction. It's not simple jurisdictional question.
Yes.
In all matters, your lordship is aware that the jurisdictional issue is raised, my lord, by the parties. The wholly without jurisdiction is of the highest order, and highest order is, my lord, that the commission did not have the power to recall its order. The argument advanced is that yes, commission has the power to recall the order, but circumstances did not exist for the recall of the order, my lord. There is a distinction. The commission had the power to do it, and commission did it illegally. So jurisdiction is vested in the commission to recall its order, but occasion did not arise.
Okay.
So rather it's a question not of lack of jurisdiction, it's a question of wrong exercise of jurisdiction, my lord.
Yes.
It's a wrong exercise of jurisdiction and to the absurd the meanest mind, my lord. So therefore, in my humble submission, the instant writ petition, the present writ petition, does not fall in any of these three categories. And this view has been taken by the division bench of this Honorable Court, my lord. We challenge this order before the Honorable Supreme Court at page 27, my lord. Next page only. And withdraw the special leave so that alternate remedy as suggested in the impugnment can be availed by the petitioner, noting of special dismissal has withdrawn. So the view was, my lord, upheld, my lord.
Yes.
So therefore, my lord, my submission is that exercise this 110, 111, all these issues can be gone into by the commission. Kindly see, my lord, the judgment on this in my compilation, my lord. Meghalaya Steel, I have already the page 28.
That
And because if your lordship will see the title of my compilation in the index itself, my lord, I have placed 6 judgment under that heading, alternative remedy, my lord. Index, if there are 6 judgment at serial number 3, 4, 5 and 6, my lord.
So 1, 3, 4 and 5 are from this court only.
Your lordship, 3, 4 and 5 from this honorable court only. I can have other judgments also, but okay. I did not multiply the authorities, my lord. And if your lordship will see, kindly see, Meghalaya also still alternative remedy, my lord. So your lordships have been consistently relegating the parties to the alternative remedy in the parameters laid down by this honorable court, that gross violation of principle of natural justice, wholly without jurisdiction, or absurd to the meanest. This is the parameter which your lordship has. Recent judgment, my lord, which is there, which at serial number 6, my lord, paragraph 16 onwards.
Paragraph 16?
Yeah, sorry. This serial number 6 at pages 34. Pages of the compilation 34. And?
Yes.
And 16 onwards. So, and paragraph, if your lordship will, is short judgment 16, if I take your lordship to paragraph 16, which is at page Page 39. 39, because it has cited all the.
Yes.
Approaching the High Court for consideration of an offer by the borrower is also frowned upon by this court. A writ of mandamus is a prerogative writ. In absence of any legal right, the court cannot exercise the said power. Mere circumspection is required in a financial transaction, particularly when one of the parties would not come within the purview of Article 14 of when a statute prescribes a particular mode, an attempt to circumvent shall not be encouraged by writ court. My submission is, Your Lordship kindly mark, when a statute prescribes a particular mode, a litigant cannot avoid the non-compliance of approaching the tribunal which requires prescription of fee, and the use of constitutional remedy as alternative. We wish to quote the Prophet recent decision in the court of Radhakrishnan Industries, my lord. After quoting, then paragraph 17, my lord, at next page 42, my lord. We shall, page 42, paragraph 17, we shall reiterate the position of law regarding interference of the High Court in Surfacy Act by quoting a few earlier decisions of court wherein it said, practice has been deprecated while requesting the High Court not to entertain such writ petition, my lord. I am not troubling your lordship with these the judgments. Lordship may take note of these judgments, my lord. Which the principle which clearly emerges, my lord, that when there is an alternative efficacious remedy, my lord, paragraph 18, where is the conclusion, my lord? Page 50. While doing so, we are conscious of the fact that the powers conferred under 226 of the Constitution of India are rather wide but are required to be exercised only in extraordinary circumstances in matters pertaining to proceedings and adjudicatory scheme qua statute, more so in commercial matters involving a lender and borrower when the legislature has provided for a specific mechanism for appropriate redressal. Same principle will apply in the Electricity Act, my lord, when there is a specialized tribunal dealing with all these issues, my lord. And when it comes to tariff policy, which has got far-reaching ramification for the state and the distribution and generation company, my lord, the remedy in law should be exercised, my lord. It is not one of those cases where remedy of writ should have been invoked and should have been gone into, my lord. So therefore my submission is based on 3 judgments and the latest judgment of the Honorable Supreme Court, my lord. It is a case where party should be relegated to the alternative remedy.
Yes.
I say so also, my lord, because of the fact, my lord, if your lordship would see the impugned judgment and order, because this is my first point, my lord. I have some more points to argue, my lord. What I was praying, my lord, that after I finish this remaining aspects, because some certain judgments have been cited by my friend also, I have to go examine those judgments also tomorrow, my lord. I will do it tomorrow.
On maintainability, I can straight away give a reply. Very
Let
short
me finish.
reply.
Let me finish.
On maintainability, because I reserved it.
I have not finished. Maintainability aspect. So, your lordship, there are other matters.
Since my esteemed colleague is not concluding today, tomorrow I have to remain here.
You join by VC also, because I will take tomorrow
Because
also.
since maintainability aspect, practically my esteemed colleague has concluded.
No, I am not yet. This is only preface.
Because maintainability, I gave my lord an indication. I did not address my lord saying that if it is argued, I will give a reply.
When I say in my counter affidavit,
Fine, but
and I take this point, then
many of us write so many things are written in the counter affidavit, all the things are not argued. And my lords have held on many occasions that merely because there are pleadings in the counter affidavit or arguments made in the counter affidavit but not argued before the Honorable Court are not to be considered. So that is why I was waiting for them to come with it. Now they have come with it, I will give a reply. So that is it. So, well, but
I'll continue with this
I
issue.
never thought that, actually, I never came with that kind of a preparation, my lord. So I'm really in a bit of a fix. preparation to stay here. This is the maintainability. Yes, I'm prepared. I was expecting it.
So otherwise, you can have it day after also if you want.
Day after, your lordship may have it in day after.
That would be so nice.
Day after, your lordship may have, because tomorrow some matters are also there.
I haven't brought clothes. Enough clothes, my lord. I have to wear. I
can't borrow.
I can't borrow clothes from my London friend. He is taller than me. That's the whole problem. I don't have that kind of a...
Sorry, a court can't give you pajamas.
Day after, my lord. Day after.
Yes, so for the hearing, day after tomorrow.
Grateful, my lord.
Interesting case.
I also enjoyed it, and it's really a delight to listen to my friend.
Erudite arguments I am privileged to hear today.
Yes.
Interim order will continue. My friend is worried not about the interim order. He's concerned only with that. His hearing is continuing.
30.
Five months.
5 months, after 5 months.
Do it the whole day for this. This is the hearing or?
It's an order. Lakshman.
Call 18. 18.
Lordship, this matter, Lordship, he has raised that.
Where is this ratio?
Lordship, he has some personal difficulty, Lordship, this time. Lordship, let them file their affidavit, Lordship.
Where's the state?
So he was here.
MSS Lalu, you are here in the matter?
18.
The one was called out earlier on. Who was there with the Advocate General? Mr. Sheikh, you're here also.
I am in item number.
Whatever is all connected, filed by the same person,
37.
correct?
37 also.
Yes, you're there also.
Yes.
Now the latest one is 444/2024.
Yes, Lordship. Lordship, everything has been explained in para 19, Lordship, with respect to that MTET. Because, Lordship, MTET is the eligibility criteria, Lordship. One of the eligibility criteria.
What's been said, you asked for 3 different types of prayers in one.
Lordship, because Lordship respondent number 8, we're challenging her 18 months as well as her MTET certificate, Lordship, because she obtained from OBC from West Bengal, Lordship.
So far as the respondent number 8 is concerned, they have got independent and separate cause of action.
That be addressed. Yes, and then
Let them file their affidavit, Lordship.
Yes.
Let them file their affidavit,
Let
Lordship.
the private parties, because these are on 18 months, because law is settled on 18 months. Law is,
No,
my
we
lord,
can't dispose without hearing the private parties also.
because first
But
private
they have
party.
been served.
Lordship, I have already.
But only issue is, my lord, that the other matter will not survive because those 18 are also, their appointment is under challenge here. So one matter can.
18, the other case. Will you take notice in this 444 also? After 1 week, you can take instruction, then we'll dispose it of.
Matters can be disposed of at least one
After 1 week, yes. This is matters after hearing submissions of the learned counsel of the parties. Yes, these matters after 1 week. Stop. It is also noted that in WBC number 444/2024, the service report on the respondents 8 to 17 is yet to be received. Yes, for Conwy. After 2 weeks, better.
After 2 weeks, also.
And Mr. Chai, take instructions where you are appearing for them, you must appear. Then we can finish up all those matters.
that the matter can be disposed of, my lord. Because now 18 months diploma has been recognized even by, yes, that is so then.
That means there's nothing to decide.
1937, correct. 1937, correct. 38, hearing.
Oh, I think we list together. I think after this.
pray for adjournment, Your Lordship, in this matter.
Would they file rejoinder or not? Yes, sir. Rejoinder has since been filed by the petitioner. This is the matter after?
After 1 week, Lordship.
Yes, after 1 week.
Lordship.
39.
Your Lordship, if this matter may come after 2 weeks, Your Lordship.
Mr. Siddiqui was waiting here. I
Yes,
saw.
Your Lordship, we got.
Lordship, this is similar matter.
It's a similar
Similar matter, Lordship.
Is there a column?
Lordship,
18
it
months.
covers the judgment of
18
the.
months DL at Your Lordship. Versus
Then we
2
listen.
years.
This is after 2 weeks also. Don't listen together, but make sure it comes the same day.
Much like Your Lordship.
Not together, but make sure it comes the same day. At the
Same date.
Same date with the Istiaq column.
40.
Your Lordship, I pray for accommodation in this matter.
You're with whom?
ML Nongpir.
Where's the other side? P. Balingyang's whom? Was Dr. Mozika? Yes, after?
1 week.
Okay, this after? This is a 24 minute after 2 weeks.
Bless you, Lordship.
That's great by the for the parties. Yes.